the fakeness. I don't ever slow up, no I don't take shit. I got no love for the fakeness. If you wanna play tough and wanna hate this, I'll always show up. I don't ever slow up, no I don't take shit. I got no love for the fakeness. If you wanna play tough and wanna hate this, I'll always show up and make a statement. I don't ever slow up, no I don't take shit. I got no love for the fakeness.
Welcome everybody, this is our vertical live. This is Justice is a Process. We are going to be watching the Ashley Benefield Day 5. We'll also join us in our featured presentation if you want to watch it in a more immersive setting. You can do that as well, but this is our mobile live. So we're going to be watching the case today alongside, like I said, we're also doing a featured live as well. So check us out. This is going to kind of appear in the shorts algorithm. So if you're new to the channel, we watch trials on a daily basis. Hit that subscribe button, hit that like button. Come on over and check out the other couple of trials. Check out our featured presentation of this trial, and then we've also got a trial that's covering out of Massachusetts right now. We've got exclusive coverage on Ty Tucker. Lots of things going on right now on the channel, but I wanted to try to reach out to a broader audience. So hopefully we accomplish that and bring attention to this very important case down in Florida. Ashley Benefield. She is a woman who was abused and ended up unaliving her husband, and the state of Florida decided to charge her in an attempt to send her away for the rest of her life. So this week, today, begins her case, and that's what we're going to be watching. So let's jump into the courtroom, guys, and get watching. Leave your questions in the chat. I'll be in and out answering those throughout the day. So let's jump in here. All right, guys. So the day is beginning here.
Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do. Thank you. Morning, Judge.
Morning, sir. My name is Judge White. I'm going to be presiding over this case. Just have a seat, make yourself comfortable in that chair. Get yourself about 12 to 15 inches from that microphone. It's pointed straight up, but it does adjust down, left, right, up, down, whatever you need. And if you just speak directly, a loud, clear voice into the microphone, it should pick up everything.
Okay, I will.
morning.
Good morning.
Will you tell us your full name and spell your last name, please?
Bruce Eric Ferris, last name Ferris.
Mr. Ferris, what type of work do you do?
I'm a licensed mental health counselor.
And how long have you held that position?
I've been doing that for 14 years. I've counseled individuals I just recently counted 1,000 clients, not including group work I've done. I also am a consultant in domestic violence and testify as an expert court witness in domestic violence.
Let's talk about your education for a minute.
Okay.
Please enlighten us.
I have a Bachelor of Science degree in civil engineering. I graduated from the Police Academy in Gainesville, Florida, and I have a master's degree in mental health counseling.
And do you have any specialized education or training in a specific field?
Yes, been to a lot of training.
Or training in a specific field?
Yes, been to a lot of training.
Particular situation,
Male privilege would not apply.
No, I wouldn't agree with you.
Okay, can you elaborate?
Yeah, the men's roles, and when you say purchasing things, I would want to look into what, is that a concept of what the role is? I'm the man, I purchase things, I control things for you, I decide what to get, et cetera. So that could be a male privilege issue.
Okay.
Poke the bear, they're afraid of the repercussions. The victim.
Do offenders always behave violently, or does the abusive behavior happen in cycles?
They don't always act violently in what common term of a battery or an assault. It can be accomplished just by threats and fear. And in terms of a cycle, there can be a violent or emotionally abusive state, and then a honeymoon side of state, and then it cycles back. In the field, we talk of a model of kind of like rain and sunshine. And,
All right, and let me ask you, Mr. Ferris, does the victim always appear to be afraid or act like they are afraid of the offender?
Definitely not. Oftentimes, the motivation is to hide the abuse from friends, family, law. There's lots of repercussions if it's disclosed. One could be fear that the oppressor, the abuser, the husband, the boyfriend, the wife, whoever is the abuser, will harm them. So they're very scared. The other is they might not even understand that they're victims of domestic violence. Quite often, when I get clients, people don't know those definitions.
How common is it, Mr. Ferris, for a victim of domestic violence to smile and act happy in the company of the abuser?
Very much so, and also in terms of even in public or with family.
Why?
Because they're afraid. They found this least resistance. They're trying to not poke the bear, as we'll say, or we've all heard the term walking on eggshells. They're trying to avoid aggression by their partner because they've grown to believe that there's a threat here.
So would could we characterize that as an appeasement?
Totally appeasement. It's something I see quite often. And if
What
I'm
is the victim trying to accomplish by engaging in the appeasement behavior?
not encourage him to be abusive to herself, or if there's children involved, she's putting up a front to again, create a type of stasis or minimum amount of aggression, so they don't want to, again, poke the bear. They're afraid of the repercussions.
All right, now give us some insight into this, if you will. Does the introduction of a child change these dynamics at all?
Yes.
Tell us how and why, please.
Okay, so it definitely ups the ante, we'll speak.
Objection, I have the same objection as at the bench.
I'll overrule on this one.
So, yes, definitely, if someone is single and they're being abused, certainly they want to incur least amount of abuse. But when a child's involved, now they're concerned, and if they have a strong maternal instinct, now they're concerned about their own safety and their child's safety. And abusers will use a child as a manipulation tool to try to get at the victim. So the victim, that's even a further degree of way to pacify. Oftentimes women will stay in marriages because they want to protect the child, even though it's detrimental to themselves.
A couple of questions about abusers, if I may. How do they generally rate on the scale of ability to charm and deceive others?
Quite highly. Those 8 years I taught domestic violence crimes, I got to know quite a few, and some were individual therapy clients also. Many of them, I used to say, have the gift of gab. They were very personable, friendly. Not all of them, but a large percent definitely were very much the charmer. They'll hide the abuse, and they use it as a strategy to influence or control their victims.
Is there a pattern, excuse me, is there a pattern, Mr. Ferris, of denying, rationalizing, minimizing, or blaming the victim in these relationships?
I can say a very high percentage, well, I don't know, over 90% I'd estimate, of all my cases involve minimizing, denying, blaming. In fact, on the power and control wheel, I guess it's gone, it's one of the 8 categories is minimizing, denying, and blaming, and it's all a technique. Like she made me hit her. I didn't really do it. It wasn't that bad. They're always trying to minimize and talk their way out of their being abusive.
Would you explain to the ladies and gentlemen of the jury, Mr. Ferris, is there a particular time in these relationships when violence is most likely against the victim?
Yes. Very much. The most dangerous time statistically is when a woman or a victim of domestic violence is leaving their abuser, and if the abuser's there. There's a high fatality rate, high incident of danger to them. I've been trained in this in my evaluation with John Hopkins' work. This is a really dangerous time. As advocates for domestic violence, we oftentimes have safety plans. Those plans, part of those plans, you never leave.
Sustained.
All right. I'd like to ask you, Mr. Ferris, if I may, a couple of hypothetical questions
Certainly.
involving a hypothetical abuser and a hypothetical victim. First, I'd like you to tell me, would the following acts be consistent with an abuser? And allow me to finish, and then you give your opinion.
I'm going to object, though.
All right. Do you want to approach?
Yes.
Tracker on the victim's car, an illegal tracker, throwing things, breaking things, yelling, screaming, belittling, cursing, humiliating, declaring such statements as rid the earth, being in a murderous mood, kill all the bad people, take them out, being caught at night, peering into windows of the victim's home, violating a no-contact order by sending a package, driving from South Carolina to Florida to be able to follow the victim, suicidal threats if the victim leaves, more than 30 years age difference, and finally, prior marital history whereby the prior wife explains how she was beat up on the honeymoon. Would that be consistent with abuse?
Absolutely, and not only absolutely, but those are checklist points right off the Duluth Power and Control wheel and right off my experience, they're stereotypical abuse techniques.
All right, and now my last question for you, Mr. Ferris, is I'm going to give you a hypothetical. And tell me if this would be consistent with someone who suffers from abuse. Sending texts that are conciliatory with friendly emojis, accompanying the abuser during child time sharing ventures, acting deferential and subservient in joint therapy sessions, but decisively different in individual sessions, fearful of the abuser finding out the victim described him as controlling, manipulative, and abusive, and being exposed to threats, intimidation, pushing, holding down, humiliating, cursing. Would that be consistent with a victim of domestic violence?
Without a doubt. These are, again, techniques of compliance, not wanting to poke the bear, walking on eggshells, trying to minimize harm to themselves and their children. They'll put up a front. They don't want anyone to know, and they don't want their abuser to be angry by them disclosing. So, yes.
Lastly, one other factor I neglected to mention, would a video of the abuser and the abused at a restaurant with the child and another adult, whereby they are all acting happy, be consistent as well?
Well, certainly, if you're asking, they're acting happy, is she still a victim of domestic violence? Definitely, and it also fits with this whole idea of appeasement. We have to remember that the domestic violence comes in layers through the years of events. So one incident.
Judge, I'm going to object to non-responsive.
Overruled.
So that behavior isn't just a spot image right then. What's going on inside her? Why is she acting that way? That's what I would ask clients. That's what we're looking for. And if it's truly a victim of domestic violence, she'll be in this appeasement mode to try to please him and not disclose the abuse to get along sort of description.
My final question as it relates in general to domestic violence. Assume, hypothetically, there were several violent or semi-violent acts of domestic violence, and then there was a break in the chain of events for, let's say, as much as a year or two, and then it started up again. Does the victim remember, and is the victim affected by the early action?
Ashley
Without a
is
doubt. I've got
a
clients.
woman on trial
Sustained.
for her life right now.
So
This
yes,
is going on live
definitely,
today in Florida.
They don't forget.
And
the
she
abuse
had
that's
to
occurred
unalive her
to them,
husband
trauma lasting.
to save her life.
Adults remember
She shot
childhood
him
trauma,
when he
let
was
alone
attacking
something
her,
from
and
several
the state
years
of
ago.
Florida has
Like I
decided
say,
to
layers
prosecute
of
her
impacts of behavior.
and try to send her away for
No
life.
further questions on this.
And this is an expert
State.
on DV, I can't say it on YouTube, who is testifying regarding
Good morning, Chris.
Good morning.
battered spouse syndrome. And you're
Mr.
about to see the state cross-examine him.
I
So
want
listen
to
up.
ask you some give you some examples and ask you if this is consistent with a victim mentality.
Sure.
Minimizing the abuse?
Now you're asking me if the victim would minimize?
Yes. Like, what I mean by that, and maybe I said it wrong, is like covering or taking blame for the abuse, covering for the abuser, taking blame.
Yes,
Okay. Making excuses for him
definitely.
or her, I guess, but not reporting the abuse.
Right.
Dropping charges if they were filed.
Yep.
Not standing up for themselves
Yes.
and not leaving.
Yes.
Okay. I'm going to put that wheel back up, and I want to talk to you about the pie sections each. if
Sure.
you could. Sorry, Judge. Well, she's fixing it, and I know you're familiar. And do you have a copy in
I
front of
do.
you? I do
want-
too.
I want
do
right in
too.
front of me.
Okay. And so I want to talk first about the use of intimidation. Would you agree that if somebody, this says making her afraid by using looks, actions, gestures, smashing things, destroying things, her property. We talked about a break. If those things weren't occurring for years, would you, but had allegedly occurred prior to that, would you still consider that part of this dynamic?
Yes.
If it's been a distance in time?
Yeah, I think the distance can be totally irrelevant.
And there's a section on here about the economic abuse. Would you find that if
Yes, this is live court.
a hypothetical victim was
This is
living on
happening
her
today
own for
down in
several
Florida.
years, had no monetary dependence on the alleged abuser, and lived in her own home in another state for part of that, and there was no monetary connection, that would not apply to a relationship.
Could you restate the
Yes.
question?
So if in this wheel,
Right.
hypothetically, when I'm talking just about using economic abuse.
Right.
Would you agree, would you say it still applies if the victim was living on her own for several years with family and independently sufficient economically? No financial dependence on the other person. Would you agree with me that economic abuse would not apply to that relationship?
From the scenario you give me, it doesn't sound like it would apply.
Okay. And for isolation, would you agree that if it's the same facts, living on her own for several years with family, so I know it says isolated from family, I think. Living on her own with family and having some periods of no contact for over a year, and then being back in contact, but living separately and having her own cell phone, having her own car, having her own home. Would you agree with me that that's not a situation where there was isolation?
Well, you have to remember, under the isolation also comes jealousy and justifying actions. So in terms of isolating, not letting their partner or the victim go to work or see family, in that sense, what you're saying is true. But a component of isolation could also be extreme jealousy, possession, your mind, those sort of things.
And I didn't add those facts. You're adding those facts, right?
Well, under the power and control world, the last item, I don't know if you actually mentioned it, using jealousy to justify actions.
And if that was not a factor, that's not a factor. for my scenario.
Then isolation component may not be part of that component for the scenario we're looking at, the couple we're looking at.
And why do you say may not? What part of that would apply?
Well, would not be.
Okay, thank you. Using the children. If the hypothetical victim had custody of the child and attempted to terminate parental rights, and the hypothetical abuser had to seek court intervention to get the child.
Right.
Would that be a factor in your consideration of whether children were being used? If she had sole control of the child?
So you're asking me if I could just reframe that the alleged abuser is not he's not using child against their alleged victim, then they're not necessarily guilty of using the children.
I'm not asking if it's guilty, I'm just asking if that would apply. 'Cause we've talked about how these
Right.
things apply.
It may not apply, it would not apply, but I think if I could mention, you're missing the point of the power control wheel. This is about pattern of behavior.
I'm not missing
Okay.
it, I'm just asking hypothetical
Okay.
questions. How about the using a male privilege? If that hypothetical abuser was not having any control over her big decisions or did not live with her, so was not being the master of the castle, was not treating her like a servant because they lived separately, and was not defining their roles, in fact, was offering to purchase things, get her anything she needed, those kind of things. Would you agree with me, if those were the facts of a relationship, male privilege would not apply?
No, I wouldn't agree with you.
Okay, can you elaborate?
Yeah, the men's roles, and when you say purchasing things, I would want to look into what, is that a concept of what the role is? I'm the man, I purchase things, I control things for you, I decide what to get, et cetera. So that could be a male privilege issue.
Okay, and I understand that, and that was a poor fact scenario in mine. I think it kind of goes with the economic abuse, and what I should have asked is, if she's asking for, can you stop and get me boxes, or can you stop and get me tape, or can you stop and get me something else, and he is.
Yes, it does,
Yeah,
David.
of course, and he doesn't. That's what I'm.
And hypothetically, these prosecutors suck.
Him.
The fact that they took this case to trial is absolutely
So
disturbing.
in terms of him buying things for her that she's asking for, I wouldn't consider that to be domestic violence.
Okay, you would not.
No.
Okay. And so that's, other than that caveat, then male privilege wouldn't necessarily apply to the cycle that we're in.
Yes, she is.
Under my facts.
The facts are
I'm
not.
not even certain
complete
what
enough for me
she's even trying to
come the
accomplish.
conclusion.
Okay. How about, minimizing, denying, and blaming? What, you said that was present in 90% of the cases.
Quite a bit, yes.
Right. I think you said 90.
I did.
What if the hypothetical abuser says, I was wrong, I lost control, I shouldn't have done those things, and never says it was your fault that you did those things?
I think her point is she's trying to paint him as saying
No.
he's
I
going to
wouldn't
say
agree with
that it's,
Because it could be that. part
he's
of
never
the
going to give an
strategy
answer that
of
would not be
minimizing
that
could be
the
that,
abuser
I'm
does
sorry,
this.
I didn't do it. That could just be minimizing.
I'm sorry no, not I didn't do it, I'm sorry I did it.
Right.
That's part of
That's still-
minimizing?
Yes.
Well, certainly not denying or blaming, right?
I would need more definitive
I
facts
guess I
to.
need an explanation, if somebody takes responsibility for accusations against them, how
Right.
that is minimizing. To say, yes, you are correct, and I am sorry I
It
did
could
that.
be a way to dialogue or to minimize what occurred by accepting blame for it, and that could be part of their scenario.
Could it also be?
she has a terrible
the opposite,
case, David.
that
A
person
very, very bad
is
case.
Taking responsibility for their actions.
Right.
Jet
certainly
Project,
doesn't-
she's accused of
it doesn't
shooting her
deny that
husband,
it happened,
who
that's for sure.
Right.
has a history of
No,
abusing not only her, but his previous
They say it's my fault.
wife.
Well, just
And the
because
state of
someone
Florida decided to
apologizes doesn't mean
prosecute
they
her and try to
weren't
send her away
abusive.
for life.
I'm just talking about the factors on this wheel,
Right.
and whether or not, if somebody, under my hypothetical, admits to responsibility for the
And if you want to see this case, there's a link
whether or not you would consider
to my
that
featured
denial.
presentation, which I'm live on
I would
right
need
now.
more information on.
This
the
one is a little
relationship
behind the
and
live,
scenario to
but you can
decide.
go over, and that one is in
Is there a scenario?
a bigger format. Jet Project, she did shoot him, but the question is whether or not it was in
How about using
self-defense.
emotional abuse? If there's
I believe she did.
no accusations
I agree,
of
Haley.
naming,
I agree.
calling, or telling her what to wear, this hypothetical victim. In fact, she's comfortable enough to wear.
Hit the
sports
like
bra
button, everyone. We need to
shorts
bring
around
attention to
him.
this case. Check
There's
out
no,
my featured
displaying
live.
Weapons.
You can also
I'm
check
sorry.
out days 1 through 4 as well in a playlist.
No.
Sorry, it's
evidence in a
exactly, but
relationship
battered
of
woman
mind
syndrome.
games
She
or
had moved
humiliating
out and was living
her
separate
or
because she
making her
fled
feel
to
bad
Florida
about
from
herself.
South Carolina
Would you
to get
agree
away
with me
from
that
him.
that might not be a factor?
So
Well,
it's battered
gave
woman
me a
syndrome with an
discrete
asterisk.
List, but emotional abuse also includes
Jet
name
Project, it
calling,
was
putting
self-defense.
someone down, affecting them emotionally.
I guess, is there a scenario, Mr. Ferris, where you will agree with me that a relationship might not include emotional abuse? Because I don't know how to give you enough factors for you to say, no,
Yeah,
it may not.
yeah, I can't help you with that. I'm not asking the questions.
Oh, I was asking you one. if there was
I
a
know, I'm
scenario.
not, you are.
Okay.
That's exactly right, Letty.
Would you take into account, based on, with these factors such as emotional abuse, economic abuse, male privilege, using children, all of these, if the alleged victim, or let me give you a scenario, she does not live with him, she's actually in another relationship, potentially engaged to a new man,
Okay,
she tells him that she does not want to be with him,
okay.
and she plans to move away.
Drastic.
without him. Would those be
This lady is accused of unaliving her husband.
Deciding if that relationship
That's exactly right, Lenny Carey. They did nothing in this case.
That would
She
be
asked for
factors of
court
the
intervention.
relationship, but
They
I
denied
haven't
her.
heard you say anything about what their history is, what trauma she's experienced,
They
what's going on
required her
with
to
children
have
in their
joint
lives,
parenting
all
sessions.
sorts of other
He
dimensions
violated
of the
protective
relationship.
orders. It's a terrible situation.
So is there no scenario where
She was
there can be
trying to
abuse
move,
in a
Garnett.
relationship and
Garnett.
then there no longer is abuse?
In fact,
where
she
they're
was
no
in the
longer
process
this
of
deal?
moving,
Because that-
and he
the way
went
you're
to
answering your
court
question
and
gives
got
the
approval to
impression I'm
move with her to
I
Maryland.
have come across situations.
And they were in the process of
where
moving,
there's,
and he was about to find out that she didn't want him to
an
be around.
emotional abuse or a physical abuse, but it's not a pattern or behavior. It doesn't go on over a period of time in an attempt to control someone. So, if I may, if someone
No
pushes
name, Drew.
down
If you
their
want the
girlfriend
quiet
on a
version,
night
click
out,
the
he
link,
gets arrested
and you can
for
go
domestic
watch that
violence
over on my
because
featured
they
stream.
live together, it's a battery, that's domestic violence, but that's it. She's not appeasing, she's not put an emotion, the whole power control dynamic isn't happening. That is domestic violence under criminal law, but it isn't domestic violence in the sense of a pattern or behavior to try to get the appeasement or this sort of consensus out of a victim where they're afraid to poke the bear, all the things I've already talked about.
We will see.
So if that answers your question.
It didn't. Is it your testimony that once a relationship has these power and control aspects, that is forever, even if there's no continued allegations of abuse for years, no continued allegations of abuse, no continued allegations of emotional abuse, never any allegations of sexual abuse? The parties are living apart. They're independently, I keep saying independently wealthy, that's not what I mean, economically independent. They are, the female is telling him she doesn't want to be with him and has moved on to a new relationship. Is there no scenario, in your opinion, where people can get off this power and control wheel, even if they were on it at some point in their relationship?
I think it's possible, but it's not likely, and it's not the typical thing that I see. Usually, there's still a dynamic of emotional abuse.
So even under my facts?
Yes.
With no allegations of,
Yes.
no allegations of emotional abuse in years?
Yeah.
It's your opinion that not good enough, they're still on this power and
Well,
control wheel?
all I can speak from my critical learning and studying this, and also my practice, and I have custody issue couples where they're domestic violence, and 10 years later, there's still abuse taking place, even though they're remarried and don't live together. So by example, I see continued abuse. Could there be a couple that don't? I'll say it's possible.
Thank you. I don't have anything else.
Redirect.
Nothing further, Your Honor.
Can this witness be released?
Yes, sir.
Yes.
Sir, you are released from your subpoena. You're free to go.
Thank you for all your help.
If you can identify it. Opportunity.
Whatever you need. And if you just speak in a loud, clear voice, we should hear you just fine.
Yes, Your Honor.
Good morning.
Good morning.
Would you tell us your full name, spell your last name, please?
Gina Torchia, Torchia.
Indeed it is, Pandora Leanne. Thank you for coming in.
Did you at one time?
And I'm sorry you had to
work
go through
for an
that.
Attorney by the name of Stephanie Murphy.
Yes, sir.
Back in June of 2018, would you have been employed under Ms. Murphy's guidance?
Yes, sir.
Do you recall exchanging an email with Detective Gillum on June 5th, 2018?
Yes, sir.
Did you have an
Guys, hit that
opportunity
like
to
button,
review?
please, for
Yes,
me,
sir.
and also hit
I'm
the
gonna
subscribe
ask
button.
you,
Get
Ms.
subscribed. We watch
Torchia,
trials
mark this
all day, every day of the week,
Exhibit number 25,
and we cover lots of cases. So check it out. Check us out.
and ask you if you can identify it for us.
Yes, sir.
What is it?
It's an email from Detective Gillum.
And does it include a response from you? Or is it a response to your initial email to him?
It's a response from my initial email to him.
Okay, and is it a true and accurate copy of your email to him and Detective Gillum's response?
Yes, sir.
Move to introduce it into evidence at this point, Your Honor, Defense Exhibit 25.
Same objection?
Yes.
Overruled.
All right, now,
Defendant Exhibit 25 will be received.
Ms. Torchia, did you on this day send Detective Gillum a copy of the South Carolina domestic violence restraining order?
No, because we were not aware of one.
Okay. Does
Maurice, this is the action here. You're watching live
He
trial,
does send
live
me a
court.
copy of the order,
This
but
is
there was
about as
never an order
action-packed as it
entered
gets.
into the Charleston County Clerk's or the Sheriff's Office.
Yeah.
So we had no proof of an order at the time.
Would you please read for us, Ms. Torchia, Detective Gillum's response to you on Tuesday, June 5th, 2018,
Gina,
6:19 p.m.?
I noticed something that you both need to be aware of, unless there's something I'm missing. If you read that section just before the judge's signature, it states the order will be in place 6 months of the day of the hearing, which was May.
Ma'am, can you slow down just a little bit?
Oh, I'm so
Thank you.
sorry. I'm a fast reader.
Okay. well,
Sorry
just
about
slow
that.
down a little bit for us.
Evelyn Wood School, huh?
Where do you want me?
You're good.
Okay,
6 months of the day of the hearing.
which was May, was May, November 3rd.
Ms. Torchia,
Yes,
I'm sorry. Would you start over, please?
yes, sir. Gina, I noticed something that you both need to be aware of, unless there's something I am missing. If you read that section just before the judge's signature, it states the order will be placed for 6 months of the day of the hearing, which was May, November 3rd, not November 27th.
Absolutely. Maurice,
And sets it to expire
Ashley
May
Benefield, the
3rd,
defendant in the
which
case,
would be 6
shot and
months
killed her
from
husband.
November 3rd.
Um,
Again,
he
it's
was
not something I would have made
an
a
abuser.
physical
He
arrest
abused his
on,
previous
but the
wife.
SAO
He began
will at
abusing
some
her,
point
this
make a
young
filing
lady.
decision.
She
If
tried to
I'm reading
flee and go
something
to
wrong
Florida.
here,
He
let me
moved
know.
down.
Okay.
They had a
We've been
child together. He
reading
tried to
Evelyn
use the child to get access
Yes,
to her.
sir.
She was
So-
trying to move from Florida to
Last
Maryland to
thing,
get away
Mr.
from him again, and
This
he
is
was
Detective
coming with her.
Gillum telling you that the order
She was trying to
was in
placate
effect,
him
stay away order,
by allowing him to believe that she was going to try to reconcile,
2007,
and there ended up being a situation where he hit her, struck her. She is a legal gun carrier, and altercation
This is
ensued, and he got
Detective
shot.
Gillum explaining to you.
Objection.
So it's a DV, battered spouse, self-defense case.
Ms. Torsion, let me pass you what I've marked as Defendant's Exhibit 26.
Can I see it, please?
Well, it's actually, the individual passed away. So this is a second degree unaliving. I can't say the M word on YouTube. Yes, Maurice, I am on her side.
Anything else?
That's sufficient, thank you, Judge.
Redirect?
No,
Can the witness be released?
yes.
Yes.
Thank you, Your Honor.
Thank you, ma'am. You're released from your subpoena.
Would you like to? Thank you.
Mr. Taylor?
Your Honor, I wonder if we could publish the exhibit that we have.
No. Please. To prove the truth of the matter asserted, for the introduction of this testimony, according to the defense, is to show the defendant's state of mind and that it corroborates her defense. Both of those sound to me like the introduction of this report to the sheriff's office regarding a tracker is being offered for the truth of the matter asserted that a tracker was placed. That would obviously make this hearsay. It's the introduction of an out-of-court statement to prove the truth of the matter asserted. That being that a tracker was placed on her vehicle, thereby corroborating the testimony that has already been provided. My notes are that it's already been testified to that the tracker was placed on the defendant's vehicle. And my notes are that she testified, or it's been established, that the victim in this particular case admitted that he placed it on her vehicle.
Matches what she said. That's not really in dispute. It's not an issue of how he was, how it happened.
I think I said this
It's an issue of what was going on in her head when she did what she
It
did.
bears repeating.
Because the state
this
believes that
self-serving
she
hearsay, it's clearly excluded.
is making up the DV part.
I will just note a secondary reason would be the relevance of this report. The issue is not whether or not she reported it to the authorities. The issue is not whether it's true or it's not true. The case law is very clear on this. It's not relevant whether law enforcement believed her or didn't believe her. The purpose of allowing these prior bad acts, and I say prior bad acts instead of going into all the different ways that can be done, but in a self-defense case, once the defendant has established there was an overt act, prior incidents of violence and intimidation and threats can come into evidence. The case law is very clear. They may be true, they may not be true. The issue is, what did the defendant know on the day that the force was used? And so those prior acts of the specific incidences of prior bad acts or prior violence don't have to have happened to her. She just has to know about them. And the tracker issue, while not necessarily violent, certainly it's intimidating. And I allowed it. I don't remember if the state objected or not, but I allowed that in. The testimony is in. Whether she reported it to law enforcement is of no moment. Whether it's true or not, because put it this way, the tracker wasn't found, so it was just an information report. It doesn't matter if it was found or not. It doesn't matter if this officer believed her or not. The issue is, it's something she's aware of. She testified to an overt act. It's already in evidence. So at this point, I will, this is not marked. What was the, I don't even, who was the next what was his name or her name?
Lindsay.
It was Deputy Lindell.
Lindsay, Scott
Scott
Lindsay.
Lindsay.
It's on the top of the report, Judge.
Scott Lindsay, I'm sorry. Lindsey.
So, I mean, you could call him, but the substance of her walking in, him taking a report, again, none of that is relevant to the issue of her knowledge of prior incidents.
That's all I was calling him for, so, yeah.
All right, I do want to give you all a break, though. I know we started at 9, it's about 10:30, I think it's reasonable to go ahead and take a break. So, why don't you guys take 10 minutes?
Thank you, Judge.
Morning.
Would you tell us your full name and spell your last name for us, please?
Vincent Vizzacaro, Vizzacaro.
All right, Mr. Vizzacaro, I'd like you to try to keep your voice up if you could.
Will do.
What do you do for a living, sir?
I'm in real estate.
Clayton
And,
Eagleton,
where are
she's
you?
never been to court prior to now
Ranch,
for anything like
Bradenton,
this.
Sarasota area.
Whereas the individual that she ended up unaliving
Residential
had been.
homes in Lakewood Ranch.
How long you been doing that?
About 8 years now.
I want to ask you whether or not, back in 2018, you had occasion to deal with an individual by the name of Douglas Benefield.
Yes, I did.
Would you tell us the circumstances under which that relationship took place?
Yes, he contacted me looking for a home.
Objection, hearsay.
I'll overrule at this point.
Thank you, Judge. Contacted you looking for a home?
Looking for a home he was trying to acquire through a business that he said he owned in Lakewood Ranch.
All right. And back in 2018, Mr. Vizzacaro, did you use emails to communicate with him?
I did.
And did he communicate with you in the same fashion?
Yes, he did.
Were emails back then a normal and customary part of your business?
Very much so, yes.
Did you preserve the emails as they related to each client's files?
I do that, yes.
And were the emails under your care and custody?
Yes.
Mr. Vizzacaro, I'm going to pass to you what we've marked as defense exhibit number 27.
Can we approach, Judge?
Yes. All right, you all can have a seat. Mr. Vizzacaro, what I'm going to do is at this moment, I need to do some research and speak with the attorneys.
Okay.
So I'm going to excuse you to the hallway. There's a thing called the rule of sequestration that has been requested by both parties. And that means that you cannot discuss your testimony or the questions asked of you with anyone else. You can't discuss other witnesses' testimony or what questions they were asked or what testimony they gave. while here in court, or do any research on the case, watch it, or anything else.
Understood.
We'll call you back as soon as we can.
Okay, thank you.
Thank you. All right, I'm just gonna ask before I start doing my research, do you have any cases that you want me to know about right now?
No, Your Honor.
All right, so
I'm-
let's, I'm sorry, go ahead.
We're traveling under the words in the statute, specifically 9803, 6.
Understood. All right, so I'm thinking it's gonna, I need about 10 minutes or so. So we're gonna take a 10-minute recess, maybe 15-minute recess. I wanna look this up as well, because I wanna find a case that gives me some direction.
Sure.
Okay, yes, sir. Thank you.
State. However, we then gave it back to the state in its isolated form. They have not filed any objection to it, so they've waived that objection according to the business records exception. We also believe that it shows Doug Benefield's state of mind, that he was in the process of buying a home directly behind Ashley Benefield's home during the time period when the South Carolina injunction was in full force and effect.
All right, anything else, sir?
No, sir.
State?
Judge, I found a case I would like to Thomas v. State.
Tiffany Collins, the trial's going on right now.
From 2000.
This happened back in 2020 is when the crime actually occurred, which is why the trial is happening
It's
now.
long to read this, but it was an email that was sent to an apartment complex manager of some sort, and it appears as though it was not qualifying as a business record, and additionally, the hearsay within the email was not admissible. There is a yellow flag, and I'm trying to look at it now.
Sorry about that, Tiffany. I didn't realize that, but I wanted to. So I guess I will redirect that to Mason. And Alyssa's, I don't know if you've watched the case or not, but there's no way if you watch this case you could think she's guilty.
The victim was trying to evict him, and that was part of the reason why he then murdered her. And the first DCA found that even if the email from the employee's side qualified as a business record, and I seem to, I don't see where they actually found and held that the email was a business record, which was my original question. But ultimately concluded that the statements that were made and then by the employee and then communicated through that business record, those statements were not, well, first they're hearsay, but they were not part of the records and the data compilations of the business itself. And that
is correct, Clayton, but
although
that would be after
hearsay
that would be if she's found not guilty. But if it's a mistrial,
business records,
she can be brought again.
those hearsay statements must still qualify under a
Also,
separate exception
Arlene
of the
Allen,
hearsay rule.
we're dealing with a lady here who unalived her
In this
husband,
particular situation,
who she says was
if I'm
abusive.
understanding correctly, what the defense is asking is to introduce Defendant's Exhibit 27 through Mr. Vizzacaro as his business record that he keeps. But according to Thomas, and then they also cited a prior.
If she's found not guilty, no name, she cannot be retried again. Double jeopardy attaches. Now, they can sue her civilly, different situation, but she cannot be tried again criminally.
1979.
Allie
Even if
Wolf,
this qualifies
I don't
as a
know why you're
business
saying
record,
that.
which
She's
again,
a woman
I have not
that
found a single case
had
that
to
says it
defend
does or
herself.
doesn't, and I don't see in my review of Thomas. where it
Mason,
says
there
it
is
or
a bunch
isn't.
of, it's admitted,
But the statements of Mr.
there's a history
Benefield,
of abuse that was brought out through text messages,
being offered to
letters
prove
from the
truth of the
defendant,
matter that he's willing to
experts.
buy a house
He abused his previous wife,
in
who
Lakewood
passed away due to,
Ranch
not
are
abuse, but
hearsay
due to
without
medical
exception.
issues.
But the exception.
And the state still brought this case.
State of mind.
It's absolutely ridiculous.
Shows Mr. Benefield, let's not forget what the defense is here. The court's allowed me now to bring in evidence of domestic violence, and here is Mr. Benefield, Judge White.
What's your basis for saying she's guilty, Allie Wolf?
To buy the house directly behind the home where Ashley Benefield lives, and he's doing it at the time the South Carolina domestic violence injunction prohibits that. He would not be able to buy that house directly behind Ashley Benefield's home. It's like 200 feet away, 100 feet away. And it's a continued pattern and practice.
Allie Wolf, absolutely, I've watched the trial, every single day of it.
That corroborates your defense.
Do you want to be heard on 90.8033, then existing mental emotional?
That's correct, Brian.
Judge, his emotional, mental state, that it still has to be material to a material fact. And his state of mind at that time is not a material fact. Also, I think the defense is misrepresenting some of what's in the email. Mr. Benefield never said he wanted to buy the house. He said he wanted to rent the house, and he said, I'll have to check with Ashley first. So I think some of the misrepresentation that's going on, we should probably just read the email. But I don't think it has anything to do with his state of mind. His state of mind at this point in time is not relevant.
Allie Wolf, as the defense has explained, she was placating him, and she didn't bring him, she brought him there because she was trying to
Are you going to
keep him at bay. And then
establish
it came
the
to a head,
location of
as you
home
heard.
through
Um,
Issacarro?
Yes, sir.
And it's exactly what the
Where it was?
experts,
Yes, sir.
In
what the
relation
last
to the
expert
house
was
where it's been
testifying
located?
to.
Yes, sir.
And then are you going to then just argue during closing? I would assume.
Yes.
All right, so there's gonna be no more witnesses. This is the end of this road to establish
Yes. This is just.
witness-wise.
This is an isolated act of DV. Yes.
It's a very clear case
All right.
that this is how women in her
Judge,
situation
you didn't
act,
actually know
and
about
that they
this, and I
do
don't want
things
this
like
problem.
that. They keep
Well,
them in
and
their
that's
life.
what I
They're
was
trying to
thinking,
placate them.
because-
They're
hold on.
trying to keep them
It's not
happy
an
because
act
there
of
was a
violence,
child
right,
involved.
or threat.
And it
But,
was all coming to
Under
a head.
9803 subsection 3, a statement of the declarant's then existing state of mind, emotion, or
Well,
physical
Ally Wolf, the
sensation,
experts
including
are
a
disagreeing
statement of
with you.
intent, plan,
Every single expert that came on the stand on
design,
cross-examination
when it's
agreed
offered to
with
prove
that what she was
the
doing
declarant's state of mind,
is consistent
emotion,
with
physical
how
sensation at the time,
women
or
who
during
are
the
victims
time,
of DV
or prove or explain
will
acts
act
subsequent
towards their
conduct
abuser.
of the declarant.
Then, Judge, I would just ask that this witness be asked questions if he is allowed to testify. I don't know why we even have to speak about an email. Just, were you helping Doug Benefield and were you looking at a certain house?
I think that would obviate some of the evidentiary concerns I have, that you asked if he was assisting him in finding a location. Did you find one? Where was
Same
that
paid
location
experts that the
that you were
state
talking
used.
about
The
putting
state
an
has
offer
paid
on?
experts, so does the defense. They're still experts on DV, and even the state's experts that were being brought in, or that were used by the state on cross-examination, agreed with the idea that her behavior was consistent with how abused women will deal sometimes with their abusers in situations, especially that involve children.
Statement of Gillum or the emails involving Stephanie Murphy does. And in the absence of a reason why it should be
Ally
kept
Wolf,
out,
it's the same, if you followed the Chris Greger case up in New Jersey. It's
Thank you
why the
very
mother
much.
was
Ally
going and
admission
staying at
of
his
Defendant's
house
Exhibit 27 under
with her son
90.803.
when the courts were not doing anything to protect her. She tried to fight in the courts, and the courts abandoned her.
Realtor's portion and 9803.
That's the part you're missing.
for
She
the
tried to
portion.
raise these issues in
With the
court, and the
understanding
courts
that,
ignored
again,
it.
This is a relatively collateral matter.
in and out, Judge.
All right, can you bring the witness back in, Mr. Visacaro? All right, welcome back, sir. Just
Ally Wolf, that's exactly what she did. She tried to go to Florida. She tried to keep him away, and he came down. He hired an attorney. He used the court system, manipulated the court system. She was trying to go to Maryland. He was following her to Maryland. She had no choice. The courts were allowing him access to her and their child. And he had a long history of abuse, which you're clearly not taking into account if you've watched this trial. You documented in the text messages she found from his previous wife, whom he kicked, hit, assaulted.
All right, y'all can have a seat. Welcome back, everybody. You ready to begin deliberations? Talk with anybody outside the jury about the case or do any research? Everybody says no. Mr. Taylor, you may resume your direct examination.
Thank you, Judge White. Mr. Visacaro, when we last broke, You told us you were a realtor and that Douglas.
Yes, I did,
Douglas
Brian.
Benefield had contacted you relative to a house in Lakewood Ranch.
That's correct.
All right, I'm going to pass to you, Mr. Vizicaro, what I've had marked as defendant's exhibit number 27. That would be the email messages that you referred to.
You are 100% right, Brian.
We were last in front of the jury, correct?
Correct.
Is that a true and accurate copy of the email exchange between you and Douglas Benefield?
Yes.
What is the date of that exchange?
The last email I see here was March 12th of 2018.
March 12th, 2018. Your Honor, at this time, I would move to introduce that into evidence on behalf of Ms. Benefield.
All right, same objections, overruled. Defendant's Exhibit 27 will be received.
Now, Mr. Vizicaro, I know you've told us that the home, do you recall the address of the home?
Yes.
What was it?
5060 Newport News Circle.
All right, I'd like, with the court's permission, to dim the lights, and we're going to put a diagram up there for you. And as luck would have it, we have the pointer. Okay, so this will give you
The beam?
the beam.
Okay.
Would you please show us on that diagram where the house was that Mr. Benefield contacted you about purchasing?
This one right here.
Right there. Now, that house, is it directly behind the house in front of it with a red dot on it?
Yes. Yes, it is.
Okay. Do you know, Mr. Vizicaro, who was living in the house with the red dot at 11331 White Rock Terrace?
No, I don't.
And do you know whether or not, if I may, you know whether or not you don't know who was living in this house?
No.
This is the house that Mr. Benefield was interested in purchasing.
Correct.
Do you know whether or not Mr. John Sant lived in that house?
I don't know.
Give me just a moment, Your Honor. I don't believe I have anything further. Mr. Vaccaro, my oversight. I'm going to pass to you what I've marked as defendant's exhibit number 28 and ask you if you can identify it.
Yes, that's the house.
That's the house that Douglas Benefield had contacted you about purchasing.
Correct.
And is that in Exhibit 28 a true and accurate reflection of the locale?
Yes,
Does it have a dot on it?
it does.
Does it have an address?
It does.
What is the address?
5060 Newport Circle. Newport News Circle,
On
excuse me.
behalf of Ms. Benefield, Your Honor, move to introduce that as defendant Exhibit 28.
No objection.
Received.
That's all. Thank you very much, Mr. Vizicaro.
No, you can leave.
Gotcha.
Cross?
So you've had the opportunity to review the email, correct?
Yes, I have.
If I could just
That's right.
grab it real quick. And for the record, this is State's Exhibit 27. And it appears as though you're speaking with Mr. Benefield about potentially this house coming up, or the price being lowered on this house, correct?
That's correct, yes.
All right. So you were contacting Mr. Benefield about that?
I reached out to him about that.
Okay. And he actually said he may just want to rent, isn't that correct?
That is correct.
And he also said he didn't want to do anything without speaking to Ashley first.
That was a comment that was later in the conversation, yes.
Okay. And if I could show you State's Exhibit 27, it's very small type at the top, so you might be able to. It's
That's why.
For the record, Defense Exhibit 27.
I'm sorry, Defense Exhibit 27.
Okay.
Does he say there that he needs to speak with Ashley first?
It appears that way, yes.
Okay.
Yeah.
Thank you. No further questions.
Any redirect?
Nope.
Can the witness be released?
Yes, sir.
Ma'am?
Yes.
All right, sir, you're released from your subpoena. You're free to go.
Thank you.
Mr. Taylor, can you state, defense, can you approach real quick?
And science. Okay, Dr. Quintel, so a couple of questions about your practice.
Yes, sir.
I think you told us your specialty was trauma.
Correct.
And for purposes of practicing your profession, various clients come to you and relate their backgrounds, correct?
Various people come to me and they've had traumatic experiences in their background. Some may be upfront in presenting them, some may not. But purpose of treatment is to get now to work better, and sometimes that requires unplugging and healing emotional wounds from the past.
And as part of your art and science, you are trained in picking up and diagnosing various cues in your effort to reach conclusions, to try and help them.
I'm not following the question.
As part of your practice, you're trained in being able to observe and detect various cues from these patients, are you not?
What do you mean by cues?
Indications of areas of trouble. For example, you don't always have patients that come out and say, oh, I am traumatized because of this. Rather, they may speak in obtuse terms, and you are charged with, among other things, trying to figure out where the trauma lies and why.
I would answer that slightly different than the way that you're framing the question. So when somebody comes in to see me, my job is to understand what's not working and really what's not working in their life today.
Okay.
If that leads us to unplugging earlier trauma, which frequently it does, great. But that's the purpose when they first come in, is me understanding what's going on with them today that's not working, and hopefully saying it back to them in a way that they're getting it, that I understand.
And in that process, you rely upon various statistical manuals and things that are reflective of your profession, do you not?
I don't do specifically a lot of diagnosing, so I'm not going to use the DSM frequently. I'm going to understand the background of why trauma sticks and how to get that better.
And to understand the background of trauma, have you in the past, or do you periodically consult learned treatises and periodicals, things that help you to reach that understanding?
If you're asking, do I go to continued ongoing training and development? Yes.
All right. Now, in this particular case, did you reach some conclusions about Douglas Benefield?
Objection, qualifications.
Sustained.
Did you counsel Douglas Benefield?
I did, yes. Both
In-
Ashley and Doug.
All right, and in counseling Douglas Benefield, did you listen and absorb the various points that he was making to you?
Yes, both when they came in as a couple and then when I did individual therapy with them separately.
And when they were in there as a couple, was part of your process observing the dynamics between the two of them?
Yeah, I wanted to understand why they were seeing me and what stuff we wanted to get better. So certainly I'm paying attention to what they're telling me, how they're communicating, what they're communicating, and such.
Okay, and part of that included how they acted when they were together and how they acted when you saw them separately?
Yes, I would say so.
Okay. Now, in making those observations and questioning them and listening to them, in your effort to try and identify the objective, did you reach some conclusions about Douglas Benefield?
Objection, foundation.
Would you approach, please?
Aviation, Dr. Quintel. Tell us what degrees you hold.
So I have a bachelor's in psychology, a master's in social work, and a PhD in clinical sexology.
How long have you been practicing as a psychologist?
I got my master's in '98 and started working in the public school system. So since '98, 2006, I started a private practice.
And since you've been in private practice, Dr. Quintel, can you give us an idea of the number of patients that you've seen and counseled?
Thousands.
And your specialty in counseling patients runs to all three of those fields that you have degrees in?
Yes, I have a background in all of that, but my specialty is in trauma resolution.
Okay, and when we speak of trauma resolution, explain to us what that is.
So I think the first thing that somebody has to understand is trauma, or what we go through, isn't troubling because it happened, which is the conventional wisdom, is that because it was awful, it still hurts. But we're not troubled because it was bad. We're troubled because when it happened, emotionally the brain short-circuited and doesn't know that particular experience ever ended. So where therapy missed the boat is we felt that people buried and repressed, and we have to help them process and get it out of them. Where the methodology that I use is the reverse. It's about getting the good news in to the emotional part of the brain that doesn't know it's over. Think of it more like unplugging the memory So emotionally, the brain can read it as data about something that happened versus where it's been stuck as happening, which explains why when somebody frequently either talks about it, is reminded of it, or is in something similar to it, emotionally they're transported back to that awful moment, right? If you have a friend telling you about something that was troubling them, and as they're telling you about it, it's almost as if they go back there to that troubling moment. So our goal is to keep the person more emotionally present as we unplug the emotional effect that the past has had.
And in that process, do you typically employ listening to patients?
Yes.
Do you typically employ making suggestions to patients?
I don't know if I would say it's making suggestions versus more kind of having a mutual outcome of how we want them to be in mind. So if I'm kind of creating a future self or an outcome, it's got to be something that they're good with, or if it shows up as conflictual, we're never going to be able to reach the outcome.
Okay. Now,
So more instead of a suggestion, it's more of kind of a mutual outcome.
all right, and you went through this process with both Doug and Ashley Benefield.
I did, yes.
All right. Your Honor, I would tender Dr. Quintel as an expert in the field of psychology.
Do you want to voir dire the witness?
Objection.
Do you want to voir dire the witness as to experience, training, and knowledge?
Yes.
All right.
You do most of your work now in trauma resolution, correct?
I do, yes.
Okay. And how long have you done trauma resolution?
Since 2006, October.
So for many years. And you said you don't do diagnoses anymore, correct?
I don't look at diagnoses with people, I look at people, because the notion of the diagnosis will help in understanding maybe some of the background of why somebody acts, but you're really working with the person. So if somebody says to me, do you treat OCD or bipolar, I would say I work with people, not the disorder.
Okay. So when you're dealing with, for instance, Doug and Ashley Benefield, you're not doing so in order to create a diagnosis or evaluate. I guess what I'm trying to get at is there's a difference between therapy and a diagnostic evaluation.
Yes, ma'am.
Okay. And so your relationship with them was what?
They were referred to me by another therapist, and my job was to do trauma resolution. What I was told is that both had their own trauma, and there was some stuff within the relationship, and that I was tasked with unplugging the emotional effect of those experiences.
Okay. Thank you. Any further questions?
You may resume your questioning.
So in treating people, not the disorder, you still, though, do you not have the capacity and the training and experience to understand if a disorder is present?
Yes, sir.
At this point, Your Honor, I would now tender Dr. Quintel as an expert.
And I
You
would
already heard
object.
any-
as to
Same
the issue.
objections?
Same objection.
All right, I will rule the objections goes to weight, not admissibility. Go ahead, sir.
Thank you. So, Dr. Quintel, all right, we're rolling.
Okay.
Did you reach any conclusions with respect to Douglas Benefield?
Yes.
Would you tell us what those were?
Based on the conversations with both Ashley and Doug, Doug occurred as someone who was domineering, and the terminology that I would use at times would be super controlling. He was very dedicated to wanting the relationship to work. He was very interested despite conversations with some of the disparaging things that Ashley had said to him. He was very much still wanting this to work, and their plans were to move to Maryland.
All right. Did you reach any conclusions with respect to him being a real alpha male? Do you recall?
I would say that Doug occurred as somebody who was very built and well put together. And yes, I would say that he would fit the stereotype of an alpha male, in my opinion.
Did you conclude whether there was an intimidation present?
Ashley stated that she was scared of Doug.
Did you reach any conclusion, Dr. Quintel, about whether Doug's depiction of himself as being godly was reliable?
Objection outside of expertise.
Overruled.
You can answer.
Can you say that again, please?
Sure. Did you reach any conclusion with respect to Doug's presentation of himself as being particularly godly?
Yes, I think it was over the top.
All right, and did you reach any conclusion as to whether it was genuine?
I did not think it was fully genuine, no.
Did there come a time when you inquired of Doug why he would want to remain in this relationship?
Yes, I did.
Why did you do that?
Ashley had a lot of disparaging comments, stuff with CPS, claims of abusing their child, and I was concerned and curious why, with all of that negative stuff that may even negative affect his job and career with government, why he wanted to stay.
And was it true that you felt he was hell-bent on being together?
I know that he really wanted the relationship to work.
Did you conclude that he was never going to let her get away?
I don't know whether that's true, whether or not. I don't recall that.
All right, let me pass this to you and see
Please.
if it refreshes your recollection, if I may.
Thank you.
Does that refresh your recollection, Dr. Quintel, as to Doug's perception of letting Ashley get away from him?
Yes, I said that to the detective. I said it seemed more like I'm not going to let her get away from me.
Referring to Doug.
Yes, sir.
All right, and lastly, Dr. Quintel, did Ashley have anything to say to you about Doug's interest in Emerson and whether or not it was just as
Objection, hearsay.
Sustained.
Did you reach any conclusions, Dr. Quintel, about Doug's interest in the child as opposed to Ashley?
Objection, Judge.
I'm going to sustain this to the opinion.
Was there an incident on one of these occasions when Doug was in your office that you thought was very strange as it related to the child?
Objection, relevant.
Overruled as long as it's factual.
Yes.
Can you say that question again, please? Thank you.
Was there an incident that you observed that you found particularly puzzling between Doug Benefield and the child, Emerson?
Yes, at the time that I spoke with the detective, I had had an appointment and Doug had waited in the reception area, and it was a couples counseling, and Ashley was out in the car with the child, and I thought it was unusual that he didn't go out and see her. Given that they had the relationship they had, it may not be as unusual as I thought, but I was coming from having two little girls and what would be in my mind to do.
And how long was Doug sitting in your office at the time? Do you recall?
Well, it would have been at least an hour. I don't know how long I was in the appointment before.
And in that hour, from what you observed, with Emerson, the child, outside in the car, Doug Benefield never once went out to say.
I wouldn't have been able to observe that because I would have been in session. I just knew that he was waiting in the lobby. I don't know whether anything other than that.
That's all, Your Honor.
Cross.
So you mentioned that it bothered you, or at least you noticed, when he didn't go out to see the child. How long did you observe Doug Benefield in the waiting room?
I would have seen him when I first went out to grab the client, and then would have seen him when I came back out of my office.
And because of that, you came to the conclusion that he never went out and saw his child?
Yes, I did.
Okay. And I believe, correct me if I'm wrong, in your direct examination, you said you met with Ashley Benefield alone 5 times.
Yes, ma'am.
And you met with Doug Benefield alone twice,
Yes, ma'am.
and you met with them together twice.
Yes, ma'am.
So the majority of the time, you met with Ashley Benefield. Over half of the times you met with her.
To do trauma resolution, yes, ma'am.
And her discussions with you and her recitations of things played into your decision about this opinion that Doug was being domineering and super controlling, did it not?
Yes, they were comments that she made and frustrations that she had within the system.
Okay. So it was not solely based on things that you were observing in Doug Benefield?
No, ma'am.
Okay. Thank you. No further questions.
Redirect.
Nothing further.
Can this witness be released?
Yes.
State.
Yes.
All right, sir, you're released from your subpoena. Thank you very much. Free to go.
Thank you.
Could we publish the couple of exhibits that we put in through Mr. Mizucaro?
That's the wrong one.
And then I think, well, once a break for lunch.
27.
I don't think that's.
Oh, that's not.
Yeah.
Oh, you have 27?
27, 28.
One photograph was already in,
One.
and then one we added together with the.
Yes, so members of the jury, we're going to pass these out and publish them. I'm not rushing you, but I'm going to talk while we're doing that. I think at this point, it's a good time for our lunch break. It's about 10 minutes after 12. So take your time. I want you to look through all of this, look through these exhibits, and then I'll excuse you.
Exhibits 26 and 27.
Those 27 and 28, and they'll be marked on them. There's a little sticker on each. Which should say 27, 28, and I think the other one is Defense Exhibit 1.
She is alleged to have, well, she shot her husband, but she says it was in self-defense. It definitely was self-defense, Blonde Bimbo. Absolutely. She's on trial for shooting her husband, who she said was an abuser, or she says he's an abuser, and she said she did it in self-defense due to being a battered woman. Garnett, yes, he did. He tracked her car. He violated a protective order that was in place multiple times. He shot a firearm in her presence to intimidate her. He threw a gun at her. He punched the dog. He absolutely was an abuser.
Just who?
We have Jason Alexander, Michael Haig, Haag, Dr. Emma
Hold on one
Lou.
second. I'm sorry. I got it. My list is, okay. Michael Haig.
Michael Haig, Dr. Emma Lou,
All right.
and Warren Justin.
He was not a good
Warren.
human at all, Blonde Bimbo. And he abused his previous wife, whom died from medical issues, not due to his abuse. And then he
All right, would we-
latched onto this young lady.
None of these, have all these folks been deposed?
Yes.
All right. Are there any objections or anything I need to hear before, before we get a jury in and get them seated and make them sit there for 5 or 10 minutes while I hear arguments at the bench? I would much, much rather have the objection made, let's talk about it, and then let's call the jury in so it's a little bit smoother.
motivation,
Okay.
did you put in none?
Well, it would have just been not filled out. Earlier, we have a detective that will go to the scene, or to the medical examiner's office to get the preliminary findings.
Let me repeat my question, Detective. Did you personally speak with the medical examiner before you submitted your arrest warrant in this case?
Not that I can recall.
What's the date?
All right, let me pass this to you and see if this refreshes your recollection.
Sure. Okay, yes, sir. Yeah, so I spoke to him on October 29th in reference to stippling.
Yeah, you documented it in your report, did you not?
Yes, sir.
All right, my last question, Detective. Do you recall filling out a...
That is true, Jacob. They did get married after 13 days. She was young, though, and he knew what he was doing.
Sir. May I look at it just to verify?
So I hold him accountable for that decision.
Okay.
Is that your report?
It appears to be. Yes, sir.
All right, can you tell us the date of the report?
November 16th at 15:10 hours.
November 16th of 2020?
Yes, sir.
All right. Let me ask you if there is a provision in this report for you to note whether...
The husband was 30 years older than her. 30 years older.
...by the offender towards the victim.
It's a program that's got a lot of different stuff, so there could be possibly, sure.
All right, let me ask you this. Under bias and motivation,
Okay.
did you put in none?
Well, it would have just been not filled out. It auto-populates. Like I said, it's a program, and I'm not a programmer, so I apologize.
So if you had been aware of bias on behalf of Ashley Benefield towards Doug Benefield, such as ill will, spite, evil intent, things of that nature, you would have noted it, would you not?
Honestly, it probably would have been just documented in the report.
No further questions.
Cross.
Tremendous age gap. You call him chaos. He knew what he was doing. He knew she was young, and that's part of what guys doing
Yes,
what he
ma'am.
was doing.
When we fill out certain
before.
areas for certain crimes, it's required for statistical reporting and things, and a lot of things that I'm not even aware of. I don't typically pay attention to that box, but
So this box is for those kind of statistics, not for any kind of bias that may be going on in this case?
correct.
Thank you.
Redirect.
That's correct, Jacob. And she got suckered in, and then that's why I'm saying she got suckered into the situation. And then when she started to realize the mistake she made,
Do you think it odd that
she fled to Florida, and he followed.
you weren't called
Beyond
by
the
the
scope.
state?
Sustained.
No further, nothing further.
Can this witness be released?
Yes.
No.
You remain under subpoena, sir. The instructions I gave you about sequestration remain in force.
Do I need to stay in the building, or can I leave?
No, sir, you can go, but you
Okay.
need to be available in case somebody calls you.
Yes, sir. They have my email. Thank you.
Good afternoon. Will you tell us your full name, spell your last name, please?
My name is Michael Haag, H-A-A-G.
What type of work do you do, Mr.?
The mistake he
I'm
made
involved in
is she
forensics.
was a
Specifically, a
licensed
typical job title
gun
would be forensic
carrier,
scientist.
and she had firearms
Let's talk
around,
about your
and she
educational background.
used it to defend herself.
Where'd you go to school?
My formal education is as a chemist. I have a Bachelor's of Science degree in chemistry from the University of Arizona in Tucson with a math physics minor.
When you speak of forensics, what are we referring to?
Forensics in the broad scope simply means the junction or the joining of science and the law. So it's where somebody who is particularly interested in or has been trained to examine physical evidence brings findings or an interpretation of that physical evidence into the courtroom.
Could you describe your forensic career history for us?
My background and training is fairly unique in that I grew
I
up
hit
in this
that like
field.
button.
My dad,
Do me
Luke
a
Haig,
favor
also
to see if we
does
can
this
get
kind of
100
work.
likes
So
on the
even in
stream.
grade school, I'd go out and assist him with both casework and research.
Hit that
And I got the
subscribe
bug.
button. We watch
So after I went to
trials every
college and
day.
got my degree, I went and worked
don't wanna
for a
miss 'em.
private consulting firm that he ran for about 2 years or so, followed by an application and employment with the Albuquerque Police Department Crime Laboratory, starting in about 1998. With APD, I worked for about 25 years and got to the retirement point and was able to retire. But during that same time frame, I also ran my own private company, specializing in my sort of primary area of interest in forensics, which is shooting incident reconstruction. The study of the physical evidence relating to shootings, the interpretation of that physical evidence, and the reporting on it, of course. With the Police Department Crime Laboratory, I wore quite a few hats. Primarily, I worked as a firearm and tool mark examiner, which someone in that role particularly focuses on the physical evidence relating to those things. But I also worked in drug chemistry as well as blood and breath alcohol, and was a supervisor of those units for about 12 years as well.
Any additional training and or classes that you have taken in order to be skilled at your job?
The list is fairly long. Honestly, I don't remember everything that I list on my CV. But as far as training and expertise, I've been trained and taken classes from everything from the FBI at Quantico to doing cross trainings with the San Diego Police Department, in-house training with the Albuquerque Police Department. I regularly attend conferences and seminars. I worked for the German Bundeskriminalamt, if you need to spell it. Bundeskriminalamt, which is like their FBI. So I interned with them for a while before I came to the Albuquerque Crime Laboratory, and a wide variety of other trainings I received over the almost 30 years now.
Are you a member of any professional organizations having to do with your specialty?
I am. The ones that are particularly relevant to what I do would be the Association of Firearm and Tool Mark Examiners, or AFTE, the American Academy of Forensic Sciences. EMFSI is one that I've been a member of for about 2 or 3 years. That's the European Network of Forensic Science Institutes. They actually have some very, very interesting perspectives on forensics, among others, including the Association for Crime Scene Reconstruction. But that's another bug I got from my dad, is being very active in the field, seeing how other units do things, as well as participating in those conferences.
Have you authored or published any scientific papers?
Quite a few. Another bug I got from my dad. I publish very regularly in scientifically reviewed, peer-reviewed journals, such as the Journal of Forensic Sciences, the Association of Firearm and Tool Mark Examiners Journal, amongst others.
Written any textbooks?
Luke, my dad, and I wrote a textbook, one of the few on shooting incident reconstruction. It's in its 3rd edition now. And I'm also
Remember,
the author
everybody,
of a
if you
chapter
wanna
in the
watch
Encyclopedia of
a,
Forensic Sciences on shooting incident reconstruction.
more normal view of this live, you can go to click the link in
I very regularly
that's
present
pinned to this
both at
stream in the
conferences as
comments,
well as
and it
for
will take you to the
organizations
featured
on this area
channel,
of work.
which is the typical normal
Tell us
stream.
what
Click that link,
certifications
head
are
over,
offered in the area of
and
firearms
you can watch
identification
a
and
quieter version without my commenting,
The primary
and
certifications, which certification applies
better
to an
version
individual,
for your viewing,
accreditation
viewing
applies to a
enjoyment.
laboratory, so those are terms you'll often hear mixed. But certifications available and that are relevant to what I do include 3 from the Association of Firearm and Toolmark Examiners, 1 in gunshot residue and distance determination, 1 in firearm identification, that's the examination of microscopic tool marks, as well as toolmark identification, the examination of microscopic tool marks from other things besides guns, like screwdrivers and hammers and things like that. And then when the International Association for Identification had a certification, they've discontinued it, for crime scene reconstruction as a whole, I applied for and took that. All these tests involve both the knowledge test as well as a practical examination. And the AFTI ones, which are still active, of course, require recurrent training and testing.
Have you been recognized and testified as an expert before in a court of law?
I have.
Approximately how many times?
At last count, I think I'm getting close to 100.
And where have you so testified?
Primarily in the area where I worked for most of my 30 years in New Mexico, in Albuquerque. But in addition to that, all across the country, to include states like California, and Texas, and Rhode Island, and I'm not sure if I've been to Florida before, but many, many states across the country, and courts ranging from district or regional courts, state courts, to federal courts, and military court martials.
Mr. Haig, have you given your opinions in high-profile cases before?
I have.
Give us an example.
The cases that come to mind would be Aaron Hernandez in Boston. That was a high-profile homicide trial. I've been involved in the examination of physical evidence in places like Taiwan, even for presidential assassination attempts. I've worked cases from Iraq and many other places that I lose track of.
Are you an instructor in any areas of forensics?
I am.
You've written on the subject as well?
I have.
And you provide regular training in shooting reconstruction?
One of the areas that I actually gain a lot of pleasure from is instruction in shooting incident reconstruction. So this is the examination, as I said, an evaluation of any physical evidence when a shooting takes place. That can involve the crime scene itself, it could involve trajectories, it can involve a wide variety of things within that sort of umbrella title. But I've taught a shooting incident reconstruction course for almost the entire last 25, 26 years of my career. They're week-long live fire shooting courses. So this isn't just a thought process. I go out and shoot things so that people that do what I do, crime scene investigators.
I just dropped a link to a live premiere tonight that you do not want to miss.
How these shootings take place,
it is
understand what they're looking at when they go into
must see.
So I do that very regularly, especially now that I'm retired. I'm able to do about 4 to 8 of those a year, it seems like.
So you can turn on your notification and get notified. It's going to be premiering tonight, 7 p.m. Eastern Time. This is a sentencing of a man who unalived a 5-year-old, and he actually asked the judge
very lucky
for
to
a life
have brought
sentence. You don't want to
into the
miss
crime
it.
scene realm. It's an engineering tool, technically. But if you think of a laser rangefinder, a very simple one that you might aim at something, push the button, it shoots out a bullet of light. Light travels at a very consistent speed. So when that light is reflected back to the sensor, time is measured, and we then can calculate a distance because of that time and the known speed of the light. That's one bullet of light. A 3D laser scanner is an engineering tool that sits on a tripod and has such a thing inside of it, but spins in a 360-degree azimuth, left and right, and also is able to shoot out the laser beam in a vertical path as well. So imagine in this room shooting out millions of bullets of light and collecting individual data points on a very accurate scale and then blending all those individual data points together. You get a representation of
For those of
reality.
you who are asking about firearms expert, this is an expert.
And then
The
you move
state
that
did
system
not
from one
call
place
a
to the next, so
firearms
you can move
expert.
around
The
corners,
defense is
and
calling
you
a
can
firearm
blend all of
expert
these data sets together
to discuss
so you can really take the crime
how the
scene
shooting
with
was
you.
done.
So I was lucky
to
enough with my
support that
police
this was
department to
done in
help start
self-defense
this
and was not done
theft of this technology into crime scene back in about 2005.
premeditation,
and since
and it was
then,
not done from a
many
distance
departments have also
that
seen the
would
value
indicate
of it, particularly with
he was
trajectories. in
gunned
my
down,
opinion.
like the state
and
has
it's become a
attempted
very
defense.
common tool across the country and internationally as well for crime scene investigation and shooting reconstruction.
Mr. Hay, can you define for us what exactly a trajectory is?
When I'm describing a trajectory, I like to think of it or describe it or liken it to a snapshot in time. If you imagine yourself in a dark room, completely dark, and things are moving, and you set off a strobe from a camera, let's say 3 times, in that dark room while things are moving around, then you've really frozen things in place for that brief instant while the strobe was going off, or in our case, when a shot is going off, because bullets move to our perception of reality in a very fast manner, of course, and so if a bullet, say, goes through something and then strikes something else, it can help us orient those objects that are struck, and indeed then where the firearm is as well. So snapshot in time is how I tend to think of it, but it's a way of understanding where things were, including potentially the firearm itself, as well as objects that are struck.
All right, so you come upon an investigation, if you will, of a shooting incident, and you reconstruct it, correct?
I try to.
All right, now would you tell us the significance, the importance of trajectory as it relates to that reconstruction?
In forensic science, you in very many ways have to throw out what you may have seen with regard to TV. Most of the things that TV puts out are completely false. But the beauty or interesting thing about trajectories with regard to shooting scenes is that fact that it gives us a way of assessing where things were in those moments of time. A person in my role may not be able to say exactly what happened in between them sometimes. Sometimes there's a logical progression of what might have happened given the physical evidence that we do have. But in my job, I basically lay the pieces of the puzzle on the table, meaning what physical evidence I have to look at from a shooting scene. And that could be the projectiles, the cartridge casings, the firearm itself, or trajectories, the room, and then try and see what snapshots in time we may have available to rebuild.
Is there a distinction between what you've been referring to as trajectory and wound path?
Wound path is sort of a subset of trajectory. Wound path refers to, indeed, just that, the path a bullet took or created when it goes through a body part in specific, or a body. But in each case, the accuracy and the meaning of those trajectories can be evaluated, because bullets, for the most part, there are exceptions, tend to travel in more or less straight paths. Like I said, there are absolutely exceptions to that, particularly with, we're not dealing with in this case, non-expanding rifle bullets, but we look at these paths as relatively linear. Every measurement taken by human beings is an approximation, though, so an understanding of how much accuracy to place on those measurements and that documentation is absolutely, of course, important as well. With trajectories into things like walls, when I have good points to work with, or data from somebody's scan of a trajectory rod in place, for example, typically about plus or minus 5 degrees is what I've found from my work, and what I would call a industry standard in my work around a measured trajectory, around a straight line, if you will, that was created by something like a trajectory rod. With wound paths, it can be a little more difficult, and this is something I've lectured on to not only the pathologists in my area, who I worked closely and well with and helped train when they'd come in as fellows, and that I've lectured on at the Swiss Wound Ballistics Workshop 2 years ago, I think, and was asked to lecture on, is the idea that not only are trajectories in bodies a little bit more inaccurate because the way they're measured and how bodies move, we're not walls, we're not rigid, so we have to indeed look at those as a little bit more of an approximation. But for the most part, with things like we're looking at here, expanding handgun bullets.
She killed her husband, Danny Daniel.
We can describe them or think of them as relatively
He was an
straight lines
abusive
as
individual, and
They
she
give us
shot
an
him in
idea where a
self-defense.
firearm may have been at the time a shot was fired based on that path. So wound ballistics is a subset of just trajectory. They're related.
You may have alluded to this. If you did, my apologies. What is the degree of accuracy of trajectory reconstruction?
With regard to common things that I typically deal with in crime scenes, like walls, sheet metal in cars, desks, almost anything you can think of, I shoot in my classes to demonstrate this and basically check ourselves and see how accurate we are, about plus or minus 5 degrees. So I'm motioning with my hands to make sort of an arc. So if my primary line of measurement, we're going right down the center of my wedge here, I'm making a visual representation of approximately plus and minus 5 degrees, a 10-degree cone overall if you rotate that into 3 dimensions, but I think I can show you that later.
What steps did you take in preparation for your testimony here today?
When I do a case review such as this, there are materials that I typically would like to see
Thank
in
you,
order
Danny.
to
Appreciate that, sir.
help inform myself on what evidence, what pieces of that puzzle are on the table to include, particularly documents, things like crime scene images, autopsy reports, lab reports, all the documentation that goes around a typical investigation, as well as 3D laser scan data, if it's available, amongst other things.
And in this case, did you examine all the evidence that was available to you?
I actually forgot to mention that. In addition to that, in this case, I did examine the actual physical evidence, meaning the projectiles, cartridge casings, et cetera.
And when you say projectiles, we're referring to the bullets?
Correct.
All right, and this information that was provided to you by the county, correct? By the sheriff's office crime scene?
Which information were you talking about?
That you were able to review in preparation for your testimony here today?
I think technically I received it through you, with the exception of the 3D laser scan data, meaning the documentation, the crime scene of photographs and autopsy reports.
Do you recall whether or not you actually came to the sheriff's office to do a review of the evidence?
Absolutely.
All right, let me ask you with that preface to tell us, please, about the projectiles in this case.
The examination of the projectiles helped me understand in a way where they'd been. This is sort of one of my main areas of interest, is the damage to projectiles sometimes, depending on their condition when they finally come to rest, can tell us something about where they've been and what they've hit, especially if we're dealing with particular types of projectiles such as we're dealing with in this case, which are expanding handgun bullets. This basically means that we're dealing with a construction that is designed to change shape if that projectile strikes something that is liquidy, and we are mostly liquid, so that would include tissue. A hollow point projectile is typically designed such that it has an external jacket made of copper. So my hands here are representing copper, and then that goes around it in 360-degree rotation. So in this demonstration, my finger's pointing up. That's the way the bullet would travel. A hollow point projectile has just indeed that, a hollow point cavity in the nose of the bullet. And it is designed that way such that if it's traveling stably, nose forward, and that hollow point cavity encounters something liquid, could be a gallon of milk sitting on a countertop, doesn't matter, or tissue. The liquid actually goes into that hollow point cavity, and because the bullet is traveling forward, you build up hydraulic pressure, liquid pressure, just like the brake lines in your car, inside that hollow point cavity. And so pressure inside that hollow point pushes the sides of the bullet open, and it comes open like this. So if I take my hands and make the model bigger for you, the jacketing material, the copper jacketing material that's facing forward as the bullet travels when it encounters something liquid and expands. Some people like the term mushroom. I don't prefer that term. But when it expands or encounters soft damage, the pressure builds up, and so that jacketing that was facing forward actually peels backwards, down, and around. But it leaves you with a forward-facing area of the projectile that's greater than the original caliber. The mushrooms
The reason why they're questioning whether it's self-defense is because
when you do that, you
they're
increase
claiming
drag.
that she
And when you increase drag, you
essentially
decelerate or slow that bullet down more quickly. And so
got
these
with him
bullets
for
undergo or
monetary
created
gain,
through intense engineering
wanted
by
to
people
become
at
a
the company
single
such
mother,
that they
who tricked
go
him
a
into getting her pregnant,
preferred depth in tissue and tissue
and then
simulator.
wanted
So
to
the main reason
then
for hollow points
set in motion a
handgun in
plan
particular,
to lure
whether
him to
that's somebody
Florida
in
so
law
she could
enforcement or somebody
unalive
interested in
him
protecting themselves,
and
as
ensure
opposed to
that
going
she
to,
had
say,
the child
range,
kept to herself.
would be to control penetration depth. So
Why,
this bullet
I
will
have
stay
no
in
idea.
one body.
This is, to
You
me,
don't
one of the
overpenetrate
craziest
and
cases
go
I've
through
ever seen
further. And I work
prosecuted with these
cases that have
circumstances.
non-expanding bullets,
Because
often called
parallel
jackets.
to that story,
Typically, you can see overpenetration.
you have
can
all
go
this
clean from
evidence
one
that this
person
man
on
was an
into
abuser,
another.
and the state
So
has chosen to ignore
that's
it.
the hollow point
And
cavity
they want to put her in
mechanism.
prison for the rest of her life. It's crazy. Go back
Where
and watch
were the
this case on my
bullets in
channel.
this case,
The
Mr.
last
Dave?
4 days are
From my
all
review,
on.
there
are
were
all in the
4 fired
playlist.
cartridge casings
Check it
and
out. You
4
won't believe it.
projectiles and 1 small lead fragment that were recovered. And we can kind of go through these because this brings
Yes, he does call him
into
chaos.
play a term called the limited universe, meaning we limit our options. We take pieces of that puzzle off the table and put them in their place. So for example, one bullet was recovered at autopsy. The entrance gunshot wound was listed as over here on the right chest, as I recall, and the bullet was recovered in the back of the decedent. That bullet, in my examination, shows soft damage, expansion, just as I would expect from bullets of this type. That bullet's wound path in the torso is well documented, and so we can kind of take one of four off the table in that the entrance hole, primarily for me in the shirt, is a nice round hole indicating that it was not unstable, tumbling, before it got there. This is basically a nice stable bullet entry, and that bullet was recovered there, so that's one of four. Another bullet was recovered after going through one of the walls of the bedroom and through several cabinets into a bathroom area. And under examination, when I looked at that bullet, it initially looked mushroomed, which is why I'm not a fan of that term, because it had the visual appearance of it, but it was just deformed. Instead of the jacketing material unfolding as I described before, how bullets do in tissue, it was just collapsed. So if you see pictures of this bullet, which as I recall, this is bullet number 11 in the crime scene images, I believe, while it looks fairly mushroomed, it does not demonstrate soft damage, and the hole going into the bedroom wall is again a nice round hole, indicating that that bullet was stable when it struck the wall, had not struck something else first. So that's two of our four bullets that are sort of off the table, and we kind of know somewhat what their story is. A third bullet was recovered down a hallway from the bedroom and in a wall. And other crime scene images indicate that it had gone through things like a book, I believe a part of a mattress, and maybe a book holder before it got to the wall where it was recovered. Examination of this bullet was very interesting in that it shows no signs of any sort of soft damage or even mushrooming of the nose. The nose is in its basically initial condition, but it has a very classic and typical characteristic to it that I demonstrate in my recon classes when I ricochet bullets off materials at shallow angles. So when I say ricochet, I mean the bullet came in at a shallow angle and continued on along its path. It's a flat spot on the ogive is the part of the bullet we're going to talk about. It's the rounded part from the nose down towards what's called the bearing surface or the cylindrical portion of the bullet. So it's a big flat spot because things like tile, what we describe as unyielding surfaces, meaning they don't give, the bullet takes up the damage, create those flat spots. In addition to that, when you look at the flat spot, you see scratches or stria on it from dynamic interaction with the surface, and those lines go straight from the nose to the base. That tells me this bullet, when it struck tile, is the likely thing in this scenario, the floor, it was stable. It was going nose first to get that flat spot and be scratched directly from the nose to the base. It then continued on down range and was stuck in the wall. That bullet gives us some idea of some trajectory, even though it's stuck in a wall just barely. You can, in the crime scene images, see it stuck in the soft drywall because it's downrange from the bedroom where all of the fired cartridge casings, biological matter on the floor is, but that hallway gives us sort of a path, a trough that the bullet had to have passed through. There were no other documented impact sites in that area, so we have what's called ballistic accessibility. It creates a path into the bedroom area. If we assume that's where the firearm was, which is a logical assumption in my opinion, based on the cartridge casings, the biological material, that doesn't overlap with another trajectory. I'll come back to that in a second. Our fourth bullet is found on the floor in the bedroom.
Check out the link
In the middle of the
to a
floor.
playlist
Its
I just
position
dropped.
to me does
This
not
is
really
a
mean
trial
much
we are
because
also
it's laying there
covering
just on the floor where it could
parallel
have
to
been
this
kicked,
trial.
could have been moved slightly, so
It has
we don't
similar
know where else it might have
circumstances.
struck in
So
that
check
room.
it
But
out.
the key thing about this bullet, and this is bullet number 5 as I recall, is that it does show soft damage. It is expanded. In the images you would see the jacketing material is peeled directly back. and
No
is facing
problem, Cat
rearward.
Mims. That's why I
The damage
say
to
it's
this bullet tells me it went
absolutely
through tissue,
makes no
something
sense
soft
with the
and
state's
liquidy,
theory.
not things like wood and drywall or glass, but rather tissue. In this case, is our limited universe option. So this bullet, number 5, would have had to have gone.
I agree
through
with you, Kimberly
the gunshot
Gott.
wound
That's
to the
exactly
leg,
right.
Which, as I recall, enters on the inter left portion of the leg and exits out to the right side of the leg itself. So those 4 bullets, and each one has a story to tell about what it did or did not strike.
When you speak of tissue, we're speaking about tissue of the human body.
I am.
Okay, just so we're clear. Now, did you bring with you today any slides or any type of diagrams that will assist you in your explanations?
I have 2 things that fit that bill. I have the Manatee County's 3D scan data with trajectories for one shot that I could show, as well as images I took of the 4 projectiles that I just mentioned that would help illustrate my points if you need me to.
All right, before we get to that, let me just finish up the wound path. I'd like to ask you about the wound path to the shot in the chest. Are you able to say, based upon your training, experience, and education, whether or not that wound, where the shooter was relative to that wound?
Of course, I wasn't there for the autopsy, but experts rely on each other's reports in order to formulate opinions. The entrance is generally on the right, front side of the chest here. The bullets were covered in the back left area. Because bullets of this type, expanding handgun bullets, travel in relatively straight lines when they go into tissue, if you simply extrapolate those lines from the autopsy report, it gives you an idea of where the firearm was. I typically speak in terms of the firearm itself as opposed to a person. Of course, a firearm is just a machine, so it typically has an operator. So how that person is directly placed with the firearm is beyond my physical evidence examination ability. But the firearm, if you put a line straight back from where the bullet entered to where it went, it gives us our best approximation of where then a firearm would have been at the time that shot was fired. Again, that snapshot in time.
Are you able to reach any conclusion with respect to the order of the shots?
Nick,
There's nothing in
what
this
footage are you talking about from
physical
Alameda
evidence
County?
standpoint
I'm
that
not certain
allows
what
me
you're
to
talking about.
sequence these shots 1 through 4. If one starts to make
Waxco,
assumptions,
LD,
which
yes,
some
there
people
is
recoil
plenty
at
of
the word
proof of
assumption,
abuse. In
as long as
fact,
you have a legitimate
verified
reason
proof,
for saying the word assumption or are willing
text
to
messages, letters, etc.
describe its validity, we make assumptions in science all the time. It allows us to make further steps. So, for example, we have 2 trajectories through the body. We have 2 trajectories into objects in the crime
The
scene.
street
If I look
team,
at the
just so you know,
trajectories
if
just
you
within
want
the crime
Quiet
scene,
Live, I have one
one that
up.
has to go
Click
through
the
that
link.
long hallway,
Well, actually, I
and
got
one
to
that we
put the
actually
link back
do
up
have
in
some
the
data
pin
for
column.
to figure
But
out
if you click,
where the firearm
I'll
was
pin
that
it
just
up.
goes into the wall within
There
the
is
bedroom.
a
And we look at
live
those
that's
2
quiet. I don't
trajectories,
comment
they
on.
don't overlap.
This is meant to promote,
Meaning
talk,
there's not a physical
discuss.
possibility for the firearm to have been stationary between just those 2 shots. I can't tell you, with regard to sequencing, which one was first. But if you make an assumption that the firearm, if you're the firearm, I mentioned right to left, moved from right to left, then the one down the hallway would have to have been before the one into the wall, if that's the hypothesis. If we take the opposite hypothesis, it's opposite left to right, that's where witness statements come into play to evaluate whether or not the physical evidence supports or refutes a witness statement. You never take a witness statement, and in my line of work, believe it. You look into what the physical evidence supports and then cross-compare them. So if you have information or an opinion or a statement that the firearm was indeed in motion from right to left, the physical evidence for those 2 trajectories would support that. As far as the body, for me, this case doesn't help too much because I focus more on the scene in this case. Others have focused on the body. But with regard to the scene itself, with the body itself, certainly we have an idea of where the firearm was relative to that body, but because those bullets don't then continue on to hit other things within the scene, I don't particularly have an opinion there that would lead me to allow me to then say sequence those in order.
Do you have an opinion as to whether or not the deceased was stationary or moving?
If we assume that the
Appreciate that,
firearm
Adventures
was
again. That's right.
relatively
That's what the
stationary,
point of me
by that
putting
I
this
don't
stream
mean a
up
matter
is,
of
because I
3 or
want to
4
have
feet.
one
I
that
mean,
is quiet and one
the
that
firearm is
can
not
talk and
circling about the
interact.
room, going out in the hallway of this.
Antoine
this
DeGrati, why do
incident,
you say that?
or
Please let me know,
otherwise,
because if you've watched,
if
I
we
assume
take
you
the
haven't
position that the
watched all the
firearm
facts
is
of this case,
generally
because I don't believe there's
just in the
anyone that would
bedroom
watch
and
the
is
facts of this
pointed
case and
in the
believe she
same
should go to
relative
prison
direction as the 2 trajectories that I've
for a
described for
lifetime.
you,
She is
then it
an
would have
abused
to be that the
woman
decedent was in motion.
who did what
Because
she
we
had
have
to do to
trajectories
survive,
in the decedent's
and that's what
body
we're
that are
hoping,
almost
that's what I'm
opposing.
hoping the jury's
We
going to
have one
find,
that goes
and I
from,
believe they will, and
as
I'll give
described
more
in the autopsy
explanation
report, and this
on
is how
that
it's commonly described in such
once
things.
we get to the
Front
end of the
to
testimony
back,
today.
right to left, and as I recall, relatively flat. I think it was maybe slightly downward, but I've forgotten the vertical component. But the key factor is that one goes this way, and as I read the autopsy report, the other gunshot wound enters the inside of the right leg and comes out the exterior outside of the right leg. These are basically 2 relatively opposing trajectories on an object that undeniably, in my work, objects, bodies,
Appreciate
regularly
you,
move
Adventures
between
again. Thanks for
shots for
coming
one
to us
reason or
from
another.
Ontario.
So
Put
given
in the
that, to
chat
me,
where
those
you're
trajectories in the
listening
body
from.
indicate to me that the body was in motion.
All right, and with respect.
That's
to
exactly right, Adam
the
Harris.
firearm
It's backing
itself,
up exactly
are
what
you
she
able to
testified
draw
to
any
on Friday.
conclusion whether or not that was in motion as well?
Certainly
he was an
within
absolute
the degree
psycho.
I've described before with the 2 trajectories that I can show you, the one that goes in the wall, for those that I can demonstrate by physical evidence, there was some motion. And as I recall from my measurements in the 3D scan data, it's something like 4 or 5 feet, at least, from one position of one trajectory's area over into the area of the other. As an approximation, again, because, again, trajectories are approximations. Otherwise, beyond that, no.
So would it be safe to say that your conclusions support the fact that both the deceased as well as Miss Pennington?
How you doing, Pam? Welcome to the chat from New Zealand. Glad to have you. My brother-in-law comes from New
I
Zealand.
can't tell you that the firearm moved
happy
from
to
right
have
to
you
left
here.
of those shots.
Happy to have a Kiwi
statement of
among
such
us.
would be supported by those 2 trajectories that I mentioned.
All right, would you please demonstrate for us now from the slides that you brought, how you reached the conclusions that you did?
Sure, it'll take me just a minute to set up
Sure,
the laptop.
Yes, please, Your Honor. Thank you.
Blended them together. This is So again, this is not a computer game. These are actually millions of individual data points. You can see in some of these places the individual spots. Each one of those is a data point collected by the scanner. And as we look down on the scene here, you're looking at the sort of wood-looking floor. You can see a tape on the floor. And now I'm going to switch perspective such that we're going to slide down to the side to allow you to get a feeling for what we're looking at. So as I move through this, you're now looking towards the doorway, exiting the bedroom, over the top of the room.
Mr. Haig, I'm sorry to interrupt.
Please.
This is the room where the shooting took place.
That's my understanding. There are certainly fired cartridge casings, 4 of them in the room, as well as a bullet hole going into the
Apologize
wall.
for whoever that John Hancock was. Enjoy your time out, sir.
That's correct. Where I'm moving my hand cursor right here in the data is a mattress.
Okay. And are you able to, from that perspective, yet see the entrance to the room?
Yes, I can swing us around so that we look into the room even, if you wish. So as I come down in the data, I can put us in the doorway.
Okay.
So that's a view into the room, and we can then even come into the room in that manner and pan around and see the room. Within the room, as I mentioned, we have a perforation into the wall, a nice round hole. As I recall, this is impact site 11 maybe, but if I swing around here, I can actually show you where that is. So the shadows you're seeing on the wall here are from the tools the investigators use. These are very common tools in our industry, trajectory rods. For this type of scanner, they often put a sphere over that rod, so that's why you see a round shape there as well. But the main point here is that there's an impact site in the wall right here. That's where a bullet hole exists. From that, I took two different approaches to create this trajectory for visualization for you. One, I simply took the scanned data, basically their trajectory rod in place, and looked at the many, many data points on that and extrapolated a line from it. If we use that method, the trajectory for that looks like this. So this is
Alarcon,
the
she's
blue
going
line.
through hell is the best way to put it.
Comes out of there. I'll
And
swing it directly above it
Catman's,
so you can get what's called
I
the
think
azimuth
I think you
viewpoint
got to
first.
wonder,
I'm gonna click
when
us
there's a
back to
camera
what's called
pointed on you and
orthogonal
you're
view.
trying to
So looking at this
go
trajectory,
through something like this, I mean,
you can see
what's
how,
the right facial
how
expression? In
as
list
viewed, it has a
879,
slight
she's Ashley
left to
Benefield.
right
She is
aspect to it, and it's
accused
traveling
of
from the bottom of
unaliving
the
her
screen as you're
husband
seeing it into the
with a
wall
handgun,
at the top of the screen.
who was
Now,
an
the
abuser.
county investigators did a nice thing. They did
And she
two
shot
different
him
ways with
in
the trajectory,
self-defense.
not only the trajectory rod itself, but they took
And
the rod
this
and they put a
expert right
laser
now is
on one
proving
end and
that
shined it across
his
the room. So the bottom wall, as you're
analysis
looking at it
of
here,
the crime
and
scene.
measured where that dot was on the
BB
wall. So I
Demand,
simply took their data
this
and
woman
connected the
that's on
dots also.
trial,
So between the
shot and
perforation in the
killed her
wall to
husband
their laser dot,
and unalived
that
him
line looks
because he
like
was an abusive man. And
that. So green and
she
blue.
shot him in
In the
self-defense.
trajectory
And
world
you're
with
hearing
walls,
expert testimony to
this
support
is
that. She
decent agreement
testified
between
on
these two
Friday.
methods as far as the accuracy that we come to. And in fact, if I put plus or minus 5-degree cones, I talked about the error earlier, on both of these, we can see that those two cones look like that. That's actually a 10-degree cone for each of them, the green and the blue. And so from the data that I have for this case, for this one shot, I would include any area within that cone, either one of those cones, as the area where the firearm would have been at the
I
time.
want to thank
that
everybody. We're
shot
at
was
93
fired.
likes, guys. I'd love
I
to
can
get
also
100
show you
likes
this
with
from
today's
the side
live.
view
We're
to give you
7
an idea of
away.
the
So if you're
vertical
new to the chat,
component.
hit that like button, guys. Help
So I'm
us
going to
get
remove
this
the
out,
left
this
wall of
case
the bedroom
out. That's
as
the
you're
goal of
looking at it
this.
here, and I'm going to swing you down.
Get subscribed. Go check out the Quiet Live, as I call it, the featured live, where you can watch this case in full screen, non-vertical. There's a link to that live pinned to the comment
From this
section.
vantage point, you can see how there is a downward component to these shots as well, going into that, I believe, again, number 11 hole within the bedroom.
Would that be consistent with Ms. Benefield firing the weapon while she's standing in the upright position?
There are certainly multiple places along these cones where a shooter could be standing. So basically, any hypothesis or any scenario that puts the gun in those cones, including that one, would be on the table. So we've seen the up and the down, the vertical component here. We've looked at the azimuth, the left and the right from above. What I'll demonstrate for you now with the data is I'm going to take you to the
One
right.
thing, if I may, Mr.
Please,
Hagan,
yeah.
as to that bullet, for the trajectory that you've just shown us, there was no indications that it had struck tissue. Is that correct?
That's correct, and I'll show you that
I
picture of
think
that
they're
bullet
talking about when
eventually.
they showed the
But this
defendant,
bullet,
like right there.
based
That's the
on
defendant.
the damage that the bullet
And
shows,
people
as
believe,
well as the nice round hole
I guess, that
going
her
into the
facial
wall,
expressions are a
this is
little
miss
weird,
of the
but she knows
decedent.
she's
This did not
being
strike the decedent.
put on video here.
If
So
I
this
take
is a
you
live presentation.
to
This
the
is a
side of
live
the cone
trial
here,
being broadcast as we speak from Florida.
the far right side of the rightmost cone, our most right option, from that position directly over it, if you look down the hallway area, you actually, there, they'll fill in, you actually cannot see where that bullet struck the wall. This area right here is to the right of the bullet's impact site. We actually have to move, as I will now, over into this area. And I'll get us right at the edge of the wall. We have to come all the way over here in order to get to the impact site, which from my examination of the images is more in this area. So somewhere on the tile in here is a bullet impact site, a ricochet off the floor. That bullet goes on and then barely perforates the drywall or penetrates the drywall up in this area. So,
And that's another bullet, is that correct?
correct, sorry, I'm on to bullet 19, as I recall, was its designator for those two.
Let me recap for just a minute. So one goes in the wall, and then one goes down the hallway.
That's correct.
Alec, Ron, yes, that's exactly what they're trying to do. They're trying to.
I don't have physical evidence that would
The
allow me to
state says it was
establish that, correct.
premeditated and that
But that
basically
bullet
there
in the
was
wall
no
down there
interaction,
also
there was
expresses
no
soft damage.
fight or
It is
struggle,
also
that
one
she
did not
essentially
strike.
went in, grabbed this gun, and he's walking in the room and she just boom, 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 3 times. The defense,
So from the 3D
her
laser scan
testimony
data-
was that
And I don't have a good trajectory or a good
basically
impact site
she was wanting him to leave for the day
to
because
look at
he
here.
was assisting
I was
her
unable to go in
in
and examine the floor. If I'd been able
trying
to
to
find that
pack
impact
up.
site,
It wasn't
I
going
might have
well.
been
It
able
was
to
getting
refine
tense.
that trajectory into
And
the wall a
she
little
had
bit better and give
essentially
us
said,
a
"Hey,
more
let it's over with. Let's
defined
go ahead
trajectory.
home." And he told her, "You need
But
to
other
start
than the ballistic
acting more like a
accessibility
wife."
aspect of going down that
It
hallway,
caused a fight.
I can't do that here.
It caused
They're
a
two separate
dispute.
trajectories that have some
And
slight
as a
divergences in the lateral
result, he
aspect.
ended up basically shoulder checking her twice.
Did I ask you
He hit her with a box,
what
which
the
there were
degree
scratches from that situation.
accuracy
And then
for trajectory
I guess
reconstruction?
I think we covered
they
that
got
turf,
into a
just that
verbal
plus or
argument,
minus
and for
5
the
degrees
first
is an
time ever, he
industry standard,
struck her in
and
the
based on
face.
having
Now,
shot
there
a
are
lot of stuff,
witnesses that
including
saw the
walls,
swelling from that
for a
blow.
trajectory like that, assuming the trajectory rod was
She
placed
said
properly,
then
about
she
plus or
kind of
minus 5
retreated
degrees
into the
appropriate.
bedroom to go get the gun, and he came into the bedroom to come continue to assault her, and she pointed the gun at him and said, "Get back," and he asserted a fight
I
posture
wouldn't describe it as
and
an
went after
interview
her.
by me. I was certainly present
And
while she described
as
the
a
incident.
result,
With respect
she
to
shot 3
the
times
description of
and then ran to the
is
neighbors.
there anything at
So
all in
the
your
state says there's no evidence that there was any struggle.
Benefield's description?
The defense's expert here is explaining that,
I
yes,
can't
that's
think of anything that would
exactly
necessarily
what
be
happened.
inconsistent.
And the state
key
is
points
claiming
that
he
come
was
to
shot
mind, where I remember
with
her
his back
saying
turned.
she stepped from her right
And
to
this
her
guy's
left
saying, no, that's
during the
not
course
correct.
of fire, that the
it's
decedent was moving
supporting-
rapidly in all sorts of patterns or manners, which would fit with the gunshot wounds entering the body in different angles. So
Oh,
from that
absolutely,
perspective,
BB,
no.
he did beat her, 110%.
Give me just a moment, Your Honor, please.
Yes, sir.
That's all, Your Honor. Thank you, Mr.
And in a little bit, you're going to be hearing from a very seasoned medical examiner from Miami,
We're able to give opinions
because we are slightly behind the live
trajectory
version of this.
for the
You're going to hear
shots into the
from a medical
That's
examiner
correct.
who's going to support as well
the human,
how this occurred.
not opine about that.
That's correct. I don't have any other sort of anchors to bring the decedent's body into play with the scene because of the lack of perforation.
Okay. And with reference to the chest wound, I saw you kind of turning several times. So, and we've had terms used such as front and side. So if you could just show the jury, where was this entrance wound?
To the best of my recollection, and of course, I could refresh my memory with images if it's helpful, but to the best of my recollection, it's in this general area on the side of the chest, and then it goes in, is recovered just under the skin in the back. So if you're sort of the firearm location, it would place the upper body in a vague general orientation like this.
So if you turned your body,
With the,
Straight.
oh, this way?
right, can you keep turning until you get to the point where, okay. So that's approximately the positioning of the gun to the body.
For the upper body, yes, I'd have no way of, yeah,
Thank
correct,
you.
yeah.
Thank you, no further questions.
Redirect,
No, sir.
can this witness be released?
Yes.
Yes.
Sir, you're released from your subpoena, you're free to go.
Thanks, sir.
Thank you. It's gonna take him a minute to put that away, and it's about 10 minutes after 3, so I don't. All right, looks like we've got everybody back. Is Dr. Lou?
So we now have the medical examiner, this is going to be a medical examiner from Miami-Dade County, who they hired, the defense hired, who's going to testify about her opinion of how this shooting went down. So this is very important testimony coming up.
Good afternoon.
Would you tell us your full name and spell your last name, please?
Yes, my name is Emma Lew, L-E-W.
And do you hold any professional degrees?
Yes, I am a licensed physician in the state of Florida, so I have an MD degree.
All right, Dr. Lou, let's take a moment. Let me just run you through your undergraduate education. Where
Yes.
did you receive that?
I graduated from the University of Saskatchewan College of Medicine in Saskatoon, Saskatchewan, Canada.
And following your college degree, you attended professional school?
I did a one-year rotating internship in Vancouver, British Columbia, and started my pathology training in Vancouver. I completed my pathology training in Saskatoon, Saskatchewan, worked for 3 years as a staff pathologist at the Royal University Hospital, then came down to Miami in July of 1991.
And with respect to your work experience, what brought you to Miami-Dade County, Dr. Lou?
I wanted to train in the
Sharon
best
Coons,
facility
she absolutely
that
did.
there
She
was
had
for
evidence
forensic
backing up that
pathology,
he
and
hit her
great
with a
one in
box on her
Canada,
hip.
and in the States
Now, the
at Go to
state
Joe Davis in Miami. So I did.
claims that they failed to
And did
document
you
it, but she
eventually
had, we heard from
rise to the
witnesses,
position of
and there was,
medical examiner for Miami-Dade County?
I believe a
Yes, when I
picture was
was in
shown as
training, I
well,
was an
supporting
associate
that she
medical
had
examiner.
swelling on
Then
her
Dr.
eye where
Davis
she was hit.
offered me a permanent staff position, and I was an associate for 10 years.
I want to ask you if you can tell us, if you can approximate the number of autopsies that you've performed.
In Miami-Dade County, it should be at least 5,000.
As part of your duties as a medical examiner in Miami-Dade County, Dr. Lou, did you also respond to crime scenes?
Yes, we responded to scenes of violent and suspicious deaths.
Would you tell us why? Well, first, let me ask, is it typical for the pathologist?
I'm sorry,
to
Vivid
respond
Fiber
to crime
666.
scenes?
If that was directed at me
Depending on
speaking,
that issue, why
then
you chose to do so.
there's a quiet
Yes, in Miami-Dade
link.
County, when law
Go ahead
enforcement
and hit
needed
that. You
a
can go to the
medical
one where you're not going to
opinion,
hear me
whoever
talking.
was on call as the
So,
medical examiner would
uh,
respond.
This
And the
is meant
purpose
to
is
be
twofold.
hearing
Number
from
one,
me
so that we
responding
can
to comments.
provide an opinion about the circumstances of death or the types of injuries on the body, and also for our benefit, so that I can see, or we can see, the body in the context of its surroundings and be able to better interpret our findings at the time of autopsy.
See you later there,
Do you
Vivid.
teach any courses?
Nice to see you.
Yes, I used
Now
to
you can
teach
go
in the medical
24
examiner
hours till I
death
see you again.
investigation course, and I still teach for the Carnival
Brian
Cruise
Herstek
Lines
or
Security
Hirsch. I'm
Conference,
not sure how to
and
pronounce
I
the
will
last name.
be
So you knew
lecturing in
them? Well,
the
that's interesting.
Miami-Dade
I'm glad you
Police
came in and
Homicide
shared your experience.
Investigations course.
And how about
Why do you
gunshot
believe
wounds?
she
Have you taught courses in gunshot
intentionally
wounds?
unalived
Not
them? I
entire
can't say
courses,
the
but I
M
have
word
taught the
on YouTube.
section about gunshot wounds in death
Are you saying
investigation
you don't believe he
courses.
was an abuser? Because I think there's an overwhelming amount of evidence that he was abusive towards
Let's
his
not
first
take
wife. He
anything
was
for
abusive
granted.
towards
If you
her.
could be kind enough, would
Um,
you
I
explain
mean,
to us,
what is it
Dr.
that
Lou, what is an
obviously
autopsy?
knowing them? I mean, did you?
An autopsy is the examination
I
of a
mean,
dead body.
there's just
It consists of
But to
two
me,
parts.
that's the problem.
One we
I
call
mean-
the external examination,
And it's
that's
all
when we
about
look
what
at
was in
the
her mind at
outside
that
of the
moment.
body
I mean, it may be
and
weird what she
describe
did
such
there,
things
having a
as
new man
height,
sit where he
weight,
did and all that
color of
stuff. I
hair,
mean, but
eyes,
to me, that doesn't
scars,
take away from the
tattoos,
fact she was,
any evidence of
it
medical
appears she was abused.
intervention, that is, any evidence that paramedics or doctors and nurses may have treated the decedent, and then any evidence of injury. After
So
looking
you
at
think
the
she
outside of
gunned
the
him down,
body,
is
both
what you're
front
saying?
and
Like
back,
she lured him
and in
into
the
the
orifices,
apartment and gunned
then
him,
we
or
do
her house
the
and gunned him
internal
down. I guess it was an
examination,
apartment.
and that's when we open up the body
Well,
cavities
I think
to
the issue
examine all of the
is
organs
the
and
fact that
tissues
you
inside
got to
the
prove
body
it beyond a
cavities,
reasonable
from
doubt.
the
I
brain
think the
inside
defense
the
has done
head
enough to be able
down
to
to the
raise a
pelvic
defense
organs.
of
That is an autopsy.
battered spouse, and I think
Dr.
that
Liu,
with
were
the
you asked
previous
to
text
assist in
messages, the
this
previous
case?
information,
I believe
the
I
witnesses
was,
that
yes.
saw bruising,
Would
that
you tell
saw
us how?
her with
I believe
scratches,
you contacted me.
you know, I think there's enough to
And
say that there's
what did
that,
you
that no
do
jury
in
will find her guilty
preparation
beyond a
for your
reasonable doubt.
testimony here
I just
today?
don't think that's going to happen.
I reviewed the autopsy report. I reviewed some of the autopsy photographs, and then other circumstantial evidence, as well as having spoken also with Mrs. Benefield.
Okay, I need you to try to keep your voice up. Did that include being present for Miss Benefield explaining what had happened?
Yes, I had made a previous trip to Bradenton and had met with Mrs. Benefield.
I'd like to ask you, Dr. Liu, about the gunshot wounds in this case.
Yes.
Will you tell us how many there were?
There were 3 separate gunshot wounds.
And would you please explain them?
Yes, one was a superficial gunshot wound on the right upper arm, and that we call a grazed gunshot wound. That was one of the gunshot wounds. Shall I explain the direction?
Please.
Now, you probably heard about
Windy City
pathways
Rose, and why do you
of
say
gunshot
that?
wounds from Dr. Vega. But as a quick refresher, if, for example, a gunshot wound was from front to back and right to left, that is relative to the person shot, not to you, not to Mr.
No, I
Taylor,
understand,
but
Brian. I
relative to
appreciate
the
you
person
sharing.
shot.
Um,
So if it's from front to back and right
No,
to
but still, that
left,
doesn't mean that, again,
it is coming in from
maybe she's not
the
a nice
victim's
person.
front
Maybe she's got
towards the back,
an error
and
about
from
herself.
his
But
right
what was
side
going on
towards his
behind
left
closed
side.
doors between her and Doug,
And
Um,
was there another gunshot wound?
I mean, in the history
Yes,
Doug
there
had
was
with
another
previous
gunshot
abuse,
wound on the right side of the chest, just
DAM, do I think a
outside of the
mistrial
right
will
nipple.
happen? No, I do not. I don't believe a mistrial is going to happen. I think it's going to be a
The-
not guilty verdict, and I think it'll be a relatively
Please do.
quick one because the
And
defense is doing a
yes,
great job. And
the
I'll give you a deeper
pathway of that
explanation
gunshot wound
because you have
happened
to
to be
understand when
from
you
front to
apply
back and right
the
to
standards
left.
you apply in a
And,
criminal trial to
I'm
this
sure Dr.
case,
Vega told
this
you
jury,
it just nicked
and
the
especially
bottom
with
of
it
the
being a
right
Florida
fifth
jury,
rib,
this jury is
went
going to
through
find
the
her not
right
guilty.
lower lobe of lung, then
And
through
Windy
the
City Rose, and I'm
part
looking
of the
forward to hearing
spine,
your
the bone of
explanation
the
as to why you
spine,
think she's guilty.
then the left lower lobe of lung, and then nicked the back of the left 10th rib.
And lastly, was there a third gunshot wound?
Yes, there was a gunshot wound. This time it was a through and through gunshot wound, or what we call a perforating gunshot wound, that entered the inside back of the right thigh, went through both right lower leg bones, and came out the outside of the right lower leg just below the knee. And that pathway was from back to front, left to right, and upward through the right lower leg.
Let me, if I may, using the easel, show you a picture.
They have, Dan, they have.
Explain to the ladies and gentlemen.
And they've done a great job on cross-examination as
You
well.
mentioned that the abrasion wound to the arm, did you tell us what the trajectory was for that?
In my opinion, the pathway of that bullet was from front to back, upward and slightly left to right.
Okay, so how, Dr. Liu, are you able to reach a decision like that on something like an abrasion wound?
Through experience and training, having had hundreds of gunshot wound cases and seen thousands of gunshot wounds and supervised hundreds more cases.
Okay, let me show you these two demonstrative aids and ask, with court's permission, if Dr. Liu could step down. I wonder if we could have the easel so I could set these up. Dr. Liu, here is a pointer that will help you.
State, feel free to reposition as you need so you can see what's going on.
Thank you, Judge.
With court's permission,
Yes,
I
ma'am, you
ask
can step
Dr.
down.
Liu to
Thank
step
you,
down.
Honor.
State, have you already seen these?
Yes. Not until now, but I just saw them.
Okay.
You have a preference of which one you'd like to see?
Wanted to say thank you, guys. We got 108 likes. Amazing, amazing job. Let's see if we can do 150 before the end of the stream. That would be fantastic. That would be out of this world. I appreciate you all hitting that like button as you come in and getting attention to this very
All right,
important
can you
stream,
tell us
helping bring
what that
attention to women that are
represents, Dr. Liu?
abused and
This is
when
the
state
grade
attorneys don't do
or
their job
superficial
and try to make
gunshot
them
wound
into
on
a
the
criminal.
outside of the right upper arm. I know there's a
Yes, a rod.
point, a rod I will use.
We have three.
Now, the reason I know that this is a raised gunshot wound is, from training and experience. Now, the direction of this projectile, you see this edge is a little bit more rounded, and because it's a deeper red, I know it's a deeper part of the wound than here, for example. Now, as the projectile skips across the skin, because it's so superficial, it raises skin, it causes skin tears and raises skin tags. Now, there's some skin tags here, but the best one is this one right here. You see this V-shaped tag? And for simplicity, how I remember pathways of raised wounds is that the skin tags point toward the gun. So, if it's pointing in this direction, the gun is somewhere along this line here. So the bullet, therefore, is coming in this direction, going from front to back. This is the front, this is the back, going from front to back and upward. And because it's on this part of the arm, you can see it's slightly to my left, to my right. So this is from front to back, upward, and slightly left to right.
If I may.
This is the gunshot wound that we just spoke about. You can see how it's going front to back and upward. This is the right nipple. This is the second gunshot wound. But it's been a bit changed or altered because this back portion that's straight.
Appreciate you subscribing,
So the gunshot wound
Along
itself
Chang.
is
I very
round
much appreciate it. Welcome from India. Anybody that subscribes, put it in the comments so I can thank you personally. I really appreciate all the subscribers here. Also, I put a link in there. Anybody who wants to become or maybe would consider in the future becoming a channel member, check out the membership levels. It's a way you can become deeper involved with the channel. Is the defender on any anti-anxiety meds right now? Not that I know of, but she could be. I would say with something like this, a lot of times people do go on anxiety medications, especially when you've got cameras in the courtroom and going through the extremely anxious, extremely It's an extremely harrowing experience when you're going through something like this. So Windy City Roses says, no, you're right, the defense is doing a good job. Well, I appreciate that. I mean, do you have any, I'd like to know your input. Nancy DC, what trial is this? This is the Ashley Benefield trial. She's accused of unaliving her husband. Windy City Rose, whose gun was it? It was her gun. She had it. Remember, they were packing to move to Maryland. She'd unloaded weapons and things from a dresser bureau. They were in the area, packing area, and she ran in and grabbed it. So it wasn't like she had it out. It wasn't like it was on her person. In my opinion, life and death of dealing with women first. Majority of women lie about anything and everything. Well, Brian Lewis, so do men. Just subscribe. Watching from Moncton, New Britain, Canada. Awesome. Thank Ash Can too. I appreciate you. No, it wasn't his gun. It was her gun. She was a gun carrying woman. She was a license to carry. This is why I say he picked on the wrong woman. He abused the woman for years in a previous relationship. This time he got the wrong woman. She fought back. She left. She had resources. She fought. She fought in court. She fled, and she was fleeing again.
I think you
and
probably return.
The good news is she carried guns, and she defended herself and did what she should have done. Nancy DC, no problem, no problem. Thanks for coming in and watching. Consider subscribing. Hit that like button as well. We're trying to get to 150 likes, and we're at 119 right now. So thank you all. Well, Brian Lewis, I don't think you can say that, sir. I think that I think it's equal. I think it's individuals and persons. I don't think you can define integrity by sex, gender, or anything else.
It's too complex for me.
It's based on the individual themselves. 45 Truth Exposed says, idiots say guilty before all the evidence that would exonerate the defendant. Maybe they're prejudiced due to how they treat women. Maybe. Probably not, though. Well, that's why you should never, ever, that's why juries are admonished all the time throughout a trial not to begin deliberating, because you should not.
Dr. Liu, did you have an opportunity prior to
Emily Porca, thank you very much. You just alerted me we're at 121. Thank you. 122 now. So thank you to all the people hitting like. I very much appreciate you.
Events that took place on that day.
Yes, I did. It may have been last year that I did that.
Is there anything at all with respect to your findings that is inconsistent with the explanation Ms. Benefield gave?
I believe that Mrs. Benefield's account is consistent with the evidence on the body, and I can demonstrate
Definitely right,
that.
Brian Lewis. We need to hear all the evidence, and I'm glad to hear that, Windy City Rose. And look, it's easy to make assumptions about cases. It's easy to make assumptions because for some reason, the overall overriding opinion about this case is she's guilty. Missed the one guy. No, verdict has not been coming. This is live. This is going on right now down in Florida. We're about 20 minutes behind the live stream and the live actual court going on today. So verdict will come in probably sometime this week.
I do not
This is
know,
the defense
however,
case.
usually
We'll be covering it live all
the
week. Get
person doing the
subscribed,
shooting does not
and
know
you can
about
check
the
it out.
autopsy
You come in
results.
and
And even if they got
Irvin
the
Solano,
autopsy
you can
report,
fix it.
they
I don't
would
think she
need
needs fixed.
someone
but
to
the
translate
domestic
the
violence cases
autopsy
treated
report
equally
for
for
them.
male
So
victims as well. I'm not familiar with these
I
cases. Of course they
doubt
are.
it, but
I think there's
again, I
a
am
skewing though,
speculating.
even when the police are enforcing things, although it shouldn't be that way because men can be a victim of DV as well as women. It's an equal opportunity server, but it's just kind of harder to envision that when you're thinking of a male in that thing. But listen, women can use objects. They can,
How many times,
they can use emotional abuse. There's all sorts of forms. So it can happen on both sides.
Pathologist and testify.
It was 3 shots, Suzette, and you have to understand, and that's what they were talking about. It's a mindset,
During
and
my
they've had an
career,
expert already
at
testify
least 500
as to,
times, and then
it's the idea that she's had all of this abuse for years, and the different things that happened to her. And in that moment, she's not firing at him as much as she's firing at her experience and what that's caused inside of her. That's why it's
Most
called
of those
battered
times I
woman
testified
syndrome.
for our state attorney.
She's defending herself against that, and it's not just the threat of what he's about to do there, it's the perceived threat based on everything he's done up until that moment. So you got to consider that. I think she may have wanted to kill him in the heat of the moment, but instantly regretted it. She might have, but I think I think she did, but I don't think she wanted to kill him. I think she wanted to get herself out of a situation. She was fearful for her
Dr.
life.
Lou, would it be helpful?
It's not about having time to leave, though, Brian. It's about she was cornered in that moment. He had hit her. He had struck her. He had threatened her. He had talked about killing people. He had talked about killing before. And boom, she needed to do what she needed to do to get out of that situation. And
I believe
if
it would add
if she
a
doesn't
new
do that, maybe
dimension
he's
to
on
the
trial, right?
to my
So
testimony. Yes.
we can only hope. Emily,
Judge,
great.
with your permission, may
That's
I?
exactly what you
Yes.
need to do. I appreciate you doing that because this is a woman who needs that, and she needs to be
May I step
found
down,
not
Your Honor?
guilty.
Yes, ma'am.
This is very clear, and the fact they took this case to trial has set back the fight for women's rights for DV and trying to help victims like of that for years. It's really sad because these prosecutors are not taking it serious at all, and they've pretty much trampled all over it. You think the social response to a male going through this would be different from the woman's experience with the demonization or justification being different? I don't know if that's the best way. Do I think so? Gavin Smith, I do, to a degree, because I think society does view this
I'm
differently.
going to sustain.
Not right, but I think they do. But I think that in the end,
Say what Ms.
would
Benefield just
would
justifying your conclusions.
I believe the first gunshot.
would it be harder for a jury to see it? I think it is, but I think that's also why you get a good
I'm gonna
defense attorney
need you
like
to
what you've
approach,
seen.
please.
You put on the experts and you discuss it, and it's also important why you have to document things and why things have to be documented. That's just ultra important.
I don't ever slow up, no I don't take shit, I got no love for the fakeness.
What in the world? So, guys, while they're on break, we'll continue talking, continue the discussion. Well, I think you got to take it serious, Gavin. We've got to make sure that we take it serious and we investigate it. It's just like what happened in New Jersey. There's a guy that's about to get sentenced for killing his son in New Jersey. The courts didn't take it serious. I think we got to take it serious. We got to fully investigate it, and we got to err on the side of caution and make sure that women, children,
Based upon your
all get
expertise and your own
access to
conclusions,
legal
Section
counsel and
3,
guidance.
Do you have an opinion as to which one of these shots may have been fired first?
I believe that the right upper arm grazed gunshot wound was the first shot.
Are you able to say why, what independent evidence exists that leads you to that conclusion?
I have based my opinions on the circumstances provided to me.
Okay. And would that be consistent, the upper right arm wound, would it be consistent with the bullet that went down the hall, for example, and lodged in a book?
Yes, it would be, because it didn't go into the body, it just went across the skin. So the bullet would be free to continue on into another room.
Okay, and because it is just a graze, it would not have any tissue effect or mushrooming, as they say, correct?
Objection.
If she can testify to that from her knowledge and experience.
Because it only grazed the skin, nothing went into the hollow point nose of the projectile to cause deformity or mushrooming of the projectile. So it would be more or less pristine.
All right. Now, you've told us, Dr. Liu, about the shock to the spinal cord from the shot that ended.
No, Windy City Rosen. If it's self-defense, that is considered to be an affirmative defense
Would that have, in
to
your opinion,
unaliving. So if it is proven to be self-defense, that removes the criminal culpability from it. That's recognized in all 50 states and federally. So if she can prove it was self-defense, and states have added and said that if you have if a woman can prove, or a
Consistent that his legs would
in
go
a
up in the air almost.
partnership or relationship can show that they were battered, that can be used to demonstrate that in her mind
Judge, with the court's permission.
she was
could the
defending
jurors
herself
perhaps
because of the
stand
previous
so that they
abuse.
could see this
And
demonstration?
that's an important factor in this case.
I'm confused as to
Now,
what we're demonstrating.
things the uphill battle to prove is battered woman syndrome normally
Oh, the shot to the
requires,
leg.
or a battered woman defense
Okay, folks, if you need
requires
to
that you live in the
stand
same
and reposition yourself,
living together and hadn't lived together for a year, or maybe a year and a half, I think, prior to this happening. So the defense is having to make that linkage, and that was part of why they had the experts come on today. 45 truth exposed. They had a stand your ground hearing, and the judge found that stand your ground was not applicable.
The gun would be somewhere along here.
So that's why that is not able to be asserted as a defense in this case. So she has to assert self-defense.
Getting shot while he's on the ground with the gun being in this position. So it's going in here and coming out here.
Okay, so this would be, in effect, a snapshot in time.
Yes, it happens very quickly.
All right. And would it be consistent, Dr. Liu, with the shot to the chest, paralysis, Mr. Benefield falling backwards, his legs going up in the air, and another shot going through the leg?
Yes.
All right.
The evidence on the body, which consists of those gunshot wounds, is consistent with that.
All right, thank you very much. Thank you, Will. I have one last question for you, Dr. Liu. You can take the witness stand. Do you recall whether there was any other injury to Mr. Benefield that would be consistent with his legs going up in the air and him falling backwards so that his head would hit a tile floor?
Yes, Dr. Vega found an abraded contusion on the back of the head. A contusion is a bruise. An abraded contusion means that there's a little bit of scraping of the skin or crushing of the skin in the center of that bruise. That is entirely consistent with Mr. Benefield's
but you have to
back
be
of the
able to
head
show
striking either the wall or the floor as he fell on his
the
back.
individual posed
Thank you
the
very
threat,
much, Dr. Liu.
and
I
that you
have no
felt your
further
life was
questions.
endangered, or that you were in danger of having a crime committed. In other words, someone's coming on your home and committing a burglary or a robbery. Then
I just want to ask you about the leg wound.
Yes.
For a
applicable.
moment.
In this case,
You're not saying that that is the only
the judge did not
position that
find that
he could have
that
been in.
he was.
No, I am not
again, the-
saying that.
the
Okay,
basis
so
for
there
standing your
are
ground
other
in this case
positions
from the
that
defense's
maybe
standpoint was he
could
was
have
going to commit an
produced that
assault,
wound path.
so she was
Yes.
defending herself against.
The one that you are
I mean, it
describing
should
is
have been.
just
I mean,
one
standing
that
ground
is
should have been
consistent
applied here, in
with
my
it.
opinion.
That is correct.
But the judge,
And,
this is part of the reason why, if you go back
When
and
you
watch the
said
first
his
4 days,
spinal cord would
this
be,
defense attorney is
I don't know
very
what you said,
active. If you
shocked?
look, I have some shorts
Yes.
on it.
I don't know
Is
what you
very
said.
much vocal about
and
the
his
fact
legs
that this
would be
judge is very
terrible.
biased against
Yes.
Ashley Benefield.
Does that normally?
In my opinion, stand your
mean that
ground
they-
should have
they
absolutely
stiffen,
applied
they
in this
straighten?
case.
Does it mean they crumble? What does it mean?
Different people react differently depending on the position that they're in. And
Well,
paralysis
Windy City
usually
Rosen,
means
what we
just
have
not
to
being
go
able to
on is
move.
the medical evidence. We have to
So
go on
depending
past
on
experiences. We have to
maybe
go
what
on
movement
the
they're
fact that
doing
there
at the
were,
time, that's what
there were
they're confused.
reporters other than
Possibly, yes.
herself. There were three
So-
other people that reported him for abuse
If he
and
is
had him
walking
reported
towards
as an
someone,
abuser of the child and her,
we fall backwards with
that
paralyzed legs?
resulted in court intervention.
Well, we weren't there, so I don't know
Convictions
exactly his
filed
body
against him that he
positioning and
violated
movements.
and that he was fighting in court. So there's a lot here that shows this guy was an abusive
And
guy.
you spoke about the
And the
abraded
state, for some
contusion on the
reason,
head, and that can be
Wants to
consistent
put
with
this before a
falling.
jury, which
Yes.
From
in
a
some
gunshot.
cases, when you have a death.
Can it
sometimes
also
the
be
state just
consistent
says, "You know what?
with
We don't
being
decide
drug out
this
of the
case.
house
We're going to
by
let a jury
EMTs?
decide it." But
Not
it's
unless
a
that
good
part
state
of
for
the
this
head
type
would
of trial
be
to
struck
happen
on
because
something,
Florida
because
is
the contusion
a
is a
state
bruise,
that
which requires
has
blunt
a long history
force.
of
Right.
not guilty verdicts.
So if, for instance, he was being drug out and hit the door jamb or something, bounced his head, could it have caused that kind of a braided contusion on the head?
Well, done with enough force, that is possible.
Okay. Thank you. No further questions.
One.
In the testimony you just heard, I know I was talking through it. This is very important because
Right
what
arm of Mr. Benefield
the
be
abraded
consistent with him
contusion on the back
lunging
of his head is
towards
the
Ms.
basis that
Benefield?
says he was facing her when he was shot, fell back, hit his head, the legs went up, which means he would
Remember,
have
the
been facing her,
pathway is
like she
from
said,
front to
and
back and
it
upward. So if he was lunging and you were the
verifies.
shooter, you can see how
There it is. She's
that would
saying
be
he was
consistent.
lunging and that this is consistent.
That's all.
So
Thank you.
that's what she said. He was lunging at her. She shot. He falls back. And this is very important because this validates and at least raises doubt as to the state's case in theory.
Thank you, Your Honor.
Thank you very much.
So it's very, very important evidence here. Very, very important testimony. Tremendously important. No, Brian, she did not hit him on the head with a weapon. What it is it's a contusion that came from the back of the head from him falling. That's what this medical examiner is saying. No, she did
All right,
not
members
hit
of the
him.
jury, there's
That's
a
not
legal
what she
argument I need to take up. If you
said,
could
and that's
step
not
out
what the
for
state
about
has
10
said. The
minutes for
state's
me,
alleging that she shot him from a
we'll do that, and we'll
distance
bring you right back.
in the back.
No
And
deliberations,
boom, boom,
no
boom.
communicate with anybody about what we've talked about the case, and don't do any research on any of the issues.
So now they're going to have some evidentiary issues. In fact, I believe the trial is for the day, for the most part, is concluded. We're going to talk about some things here in a minute. If you guys are interested, I'll take some questions from you guys from what we're watching. We'll be back again. We're watching this again tomorrow. So get subscribed, get your notifications on, hit that like button as well. Get this stream liked and push it into the atmosphere. 132 likes. So
Okay,
I'd like
well,
to
you
get
all
to
can exit the
150,
jury's
guys.
out.
Let's do it.
And was this the issue, the Richardson?
No, this is the DNA issue.
Oh, yes.
And I have the following case for the court. Ladies,
Thank you.
may I?
Yes, sir.
Mike Jones, she had bond. So she does have bond. She's out on bail. She's been out on bail since I think she only spent a couple of days in jail. I don't believe it was long, and she's gotten bond. So she comes in every day. If you watch at the beginning, go back and rewind to the back of to the beginning of the day on this stream or my featured stream that has everything on it. Sucks that the law system it does. Well, it's a tough. It's a very nuanced thing, Windy City Roads, and it's a very, very difficult thing to prosecute because it's all subject to a lot of trying to figure out what exactly was going on, and you've got to make sure that when it's happening, you've got kind of the issue we have at hand is you have to respect the rights of the accused, which is the individual accused of domestic violence. And then you also have to protect against the time it takes them to go through the justice system, and then also protect the alleged victim. I have a story of my own. I'm actually a witness. I will be a witness. I was out. I have a dash cam in my car, and I caught a man beating up his wife. I called the police. He ended up getting arrested. I assisted in helping the police track him down. So this stuff happens, unfortunately, all too frequent. And I found out this guy that got arrested that I witnessed, third time he was getting arrested. He had 3 active cases. So this was his third time. So if he were to get convicted of the other 2, which were pending, he was out on bond, and he had 3 active cases. And this was the third one he caught. So it's like, This time though, they said the other two were instances that the lady called. This is the first one that they got independent witnesses and actual video of what he did, thanks to yours truly. So this time he's going to get held accountable. Mock toe, what you talking about? Come on now. Keep it clean. Keep it clean.
That's why standard we usually see is one of the parties, whoever it is, whatever the evidence is, calling the DNA analyst, generally act.
The fact that those swabs are identified to Ashley Benefield or Doug Benefield is hearsay to DNA labs. That means some crime scene tech who did not testify before this jury went and collected his DNA stain card. A different crime scene tech who testified she swabbed her but was not shown swabs to make sure those are the correct swabs, then swabbed her and put those in proper evidence. That's all. We don't have any evidence that the same swabs that she was
Beauty is her
collected,
name. This is
then
the
went
Ashley
to
Benefield
DNA labs.
case.
And that's what you have to have to lay the
Out of Florida.
foundation. And
She's
just-
accused of
this is the
unaliving
case
her
I was
husband.
referring to when I didn't refer to it by name, but this is what I read when I made
Windy
my
City
objections.
Rosen,
My
yes.
objections are
At least in the
whatever
past,
stated,
but
but
that's what the
also
defense
for
has been
just that
very
lab
vocal
report
about, saying
in
that
evidence. This
a
is
lot of the
very
rulings
confusing.
that the
It's
judges
DNA.
made, the
And it's
objections, they's limited the
overly
scope
prejudicial
of
to this jury
cross-examination.
for what I think what it says is the state never, this state didn't argue, and I am arguing.
Unfortunately,
How the
yes,
forensic case works
that's
would
what
be unfairly prejudicial or
appears to be
confusing in
happening.
regards to the work of the jury. This is DNA.
Marty
It's
McFly. Why do you
I don't
say
know.
that,
They
Marty?
sent us the
Why do you
bench
say
notes
that?
and the report, but there's no explanation.
Enlighten
of
us.
the how they came upon those statistics, where those swabs came from, all those
All right,
things.
guys,
and I
we're
think
12
that would be
likes
very
away from
confusing
hitting
to the jury
150.
without somebody here.
We need
So
to
I'm
get
not
them in.
making
We
a
got
certified records objection.
we
I'm
got
making
enough
a
of you in here to get
context.
12 more likes.
And
Let's
there
do
hasn't
it.
been an adequate foundation in that there
Let's do it, guys. Come on.
Sir, any rebuttal?
Hit that like
The
button.
court recalls that Detective Warren said.
Look at her body language and the pausing is off. Well, that's the prosecutor.
Megan Dorvac testified that she swabbed Miss Benefield. I asked her why. She said because
I think sometimes judges are just, wired sometimes to be more,
Miss Benefield
to be a little more,
Miss Benefield grabbed her by the hand and spun her around
sometimes
as she tried to leave the house.
are wired to be
This
amenable to the
report
state.
corroborates
Sometimes that's
that
just what happens.
To the extent of, I think, 720,000 times, more likely.
Emily Porica, yes, you're correct.
We think.
And it
it's
is our
an
business. You see
essential
someone getting
component
abused, you've
of
got to
defense.
step
Now,
up.
We don't have any, chain of custody is.
Dawn
irrelevant.
Bowden, the story is Ashley Benefield
Even
is
though
accused of
they
unaliving
just
her husband,
basically
who
undermined
was
the
an
road
abuser,
chain of custody.
a verified abuser, and
It's not an issue.
a very sad
The
case.
result that for our purposes and our defense is essential, Your Honor. This case allowed it to be admitted as a business record. The assistant has made eminently clear that that is not why she's challenging it as a business record. I don't seek to introduce the entire report. I will be quite happy reading these two sentences, if I may.
Thank you, because I haven't seen this. Thank you. All right, final thoughts? Is that everything?
Yes, sir.
This is.
Andy Barth, the trial has been going on
Marked
since
as
last Tuesday. Jury selection
exhibit.
went on for, I
It's a
think it was 2
5-page
or 3 days of
document
jury
from DNA
selection.
Labs
And
International.
then Tuesday, they had opening statements.
It
If you want to check
actually-
out the rest of the trial, check out my playlist.
It's a
I have it
letter or
on my
report
channel. You can watch the first 4 days,
to
including today's
Detective
trial,
Justin
and
Warren
it is in a different, it's
and
not in
his
vertical format. It's in a
sergeant
very nice to
Atlanta
consume,
County Sheriff's Office.
long form.
And it is signed by Jerome Rim, REMM, forensic DNA.
You can also go back and
analysts.
rewind and catch up on what you missed on this stream.
It lists a number of items.
Throw him in with some big boys, Tim McLaughlin says. Well, it's a female that's on trial. I don't know if you're talking about the
14
judge.
different items that were.
Oh yeah, Windy City Rosen. She
Apparently
she
sent to
she was the
DNA
gun owner.
labs.
She back when they met the first night these people the two met.
For
She was
DNA
at a
testing.
Republican political convention. It was at the 2016 when Trump had got elected, and she had a gun in her bra. She used to carry a gun in her bra. She had a license to carry. And that was how they bonded, was over her carrying guns. He was an avid gun
And
carrier
the
and user.
Particular section, the defense says they want
So
to
yeah, she's
admit
very proficient with firearms. Suzette Royal, I don't know why. I don't know
agency
why. I
item
think it's
number
because,
MRD5, which would correspond
you know, I think it's
to
just because,
DNA Labs International item
you know,
20-10.
probably a mixture of how they were treated as from their childhood
right hand.
to also just the domineering nature sometimes of
says that
men,
the-
and they don't understand
Testing was done.
how to do it another way. I mean, I think it's I don't know. It's a
Mixture
tough
of
tough
two
question.
individuals, at least one male contributor.
Well, I don't think she shot to kill Windy City. She fired 3 shots to get him away.
And it says Doug
Love
Benefield and
cabbage.
John Sand
I remember
could not
you.
be ruled out as
My old
possible
friend.
contributors to this
My old
foreign
friend,
DNA
Muff.
profile.
Way back in the Nikolai Mew case.
And it gives, based on its testing,
Too tall. This
different
is the Black Swan
propositions,
case. Absolutely, it is.
that were considered to explain.
Where did the shots hit him? They hit him in
the
they hit him in the
results.
arm. They hit him in the leg,
One
and I
is
believe it hit him in
The
the
DNA profile
the chest.
obtained from the swabs.
because he was coming at her
720,000
lunging, and that's what
times
that
more probable
medical
if the
examiner
sample
testimony was
originated
about.
from
That it was consistent
Ashley
with him
Benefield,
lunging forward
Doug
and then
Benefield, and
getting
two
hit,
unknown
falling back, and
persons
hitting
than
his
if
head.
it originated from Ashley Benefield and 3 unknown persons. So there's strong support that Ashley Benefield, Doug Benefield, and 2 unknown
Well, it's
persons
tough to know the
contributed to the
order,
profile
Windy City, but I
rather
think
than Ashley
we
Benefield
kind of
and
do. I
3
do
unknown
believe
persons.
the Nephilim crew, 143. Thank you for alerting me, guys. We're at 143. Let's get 7 more. Get to
I am.
150
I'm
before the end of
reading
the
it as I
stream.
go.
Okay, thank you, sir.
And yes,
If
you're correct,
applicable
Paul
to the
Bowden.
case,
There
it is
are
recommended that
men and
reference
women
standards
that
from
do
any
abuse each other.
first-degree relatives of
There's
Doug
equal
Benefield
opportunity for
be
abuse
submitted
on
for
both
additional
sides.
comparisons.
It's all about exactly right. Childhood trauma,
And I
what
think
they
this
what
is
you've
the second
experienced as a
proposition
child,
that
poor
Labs
social
is
skills,
considering.
poor way of
The
relating,
DNA lab profile obtained
various
from the
different
swabs
things, poor anger
is
management,
approximately
and
75 million times
it's
more
just
probable
it's something that I
if the
think
sample
that
originated from Ashley Benefield and 3
know,
unknown persons
stop it doesn't
than if
just
it originated from
start
Ashley
at the punishment
Benefield,
level.
John Sant, and 2 unknown persons.
Ruth
Therefore,
Rodriguez.
there's
Thank
extremely
you.
strong support that Ashley Benefield and 3 unknown persons contributed to this DNA
145
profile
likes, guys. Let's get to
rather
150
than
before the
Ashley
end of this.
Benefield,
Thank
John
you.
Sant, and 2 unknown persons. The DNA profiles of additional contributors to the mixture were not determined. However, there's results that are suitable for comparison. All right, so obviously those of us who have done a number of these cases understand what those statistics mean when you're looking at known standards versus unknown DNA samples or swabs and the comparisons. I am not sure, and I do not have the belief that the interpretation of DNA results.
Well,
as
too tall.
outlined
I
in
saw
these DNA
tears. I
labs
saw tears on the stand. I
report
thought it was very sincere,
is within the
crying
common
on the
knowledge
stand. But
of
again, maybe that's just me. But I thought
a
it
lay
was
juror,
sincere.
a regular juror.
I thought it was sincere.
That's why
All right, guys, we're at 147 likes. Let's keep it
Standard
coming.
we
Come on,
usually
guys. We can
see
do this. 3 more.
is one of the parties, whoever
Hit
it
that like
is,
button.
whoever the proponent of the evidence is, calling the DNA analyst, generally after showing and evincing whoever took the sample, packaged it, where it was stored. It was then sent from the property and evidence room to the DNA lab. Then the DNA lab analyst will say how they went and got it. And I'm just going to disagree that chain of custody is not important. That's why we have it, and that's why we have certain predicates to establish evidence from a crime scene to court and who touched it and how it changed and what was done to it. So I disagree that that's not important.
Isn't that when the defense contests?
In the problem, well, I gave everybody the chance to argue.
Sorry.
So I got a chance to read the shorter case, and the shorter case supports what the court is saying. It says that they leave the issue for another day, whether it could qualify as a business record. However, there remains, and this is at 692 of the decision. However, there remains a very significant section 90.403 concern about the admissibility of a DNA forensic report if the expert preparing the report does not testify. And the reason the fourth DCA, it says so in the very next
V-trips,
paragraph, the
definitely
reason the fourth
self-defense. I think that's where the
DCA
chat's going. Let's
upheld
do a poll here and see what we think here.
admission
Best way to
was
find
for that
out.
very reason, that the state did not argue 403.
$152 likes. Thank you, Andy Barth. I appreciate everybody. I appreciate everyone who
And
helped
here
me
they
get there.
are.
So, thank you very,
Here
very,
the-
very,
the
very
state
much.
has
That
argued the
153,
403.
guys. Maybe we'll crack 200. Maybe that's
For
a
a
bit
jury
lofty,
to
but
understand
why not, right? All right, let's see here. We started our poll,
what these mean,
and we are
what
getting an
these
overwhelming amount of
findings
not
mean.
guilties right now. So get your
I
votes
don't
in, guys.
find that
Get your votes in.
The
We
probative
will
value is,
look at the final results
I
at
do
the end
find
of
the
the
probative
stream,
value
which will be
is
coming up here shortly.
substantially outweighed by the danger of the confusion
Get
of the
those,
issues.
hit the like button, get
misleading
your
the
vote
jury to
in, and
try
we're going to have a
understand,
conversation here in a minute.
What this report says. And be subject to cross-examination from, well, this time it'd be the state, but it's usually the defense, to explain, where do you get this? How do you get 720,000 times? How many loci were matched? How did you conduct these evaluations? And then, what does it mean, the very strong support?
That is.
And then it's also, you've got, the other problem is, Mr. Taylor, you're telling me you only want to read this, you said 2 sentences. Yeah, these 2 sentences that are highlighted.
Correct.
But that's only one of the 2 sets of propositions that could potentially explain this. And the first proposition you want to use doesn't even mention Mr. Sant. And if I'm reading this correctly, there's also a recommendation that there should be some additional testing. There's also additional DNA profiles that are in these mixtures from Ms. Benefield's right hand
45 truth exposed,
that
that's
are suitable
correct.
for comparison and have not been compared.
He,
So,
well, he was married
I have
once before, and he put hands on her, admitted to it.
misleading
There's
of
text
the
messages
jury by
verifying
putting
it.
this
So,
in.
yes, this guy definitely has a history.
And I make my record.
it would, if it would,
V-trips. So, V-trips, run down to the case. This is a situation where this lady met this man that she unalived. Within 13 days, he convinced her to marry him. He got his vasectomy undone. He had 11 months before his wife had died of a medical issue, a wife that he abused, that he abused both financially, physically, mentally, verified through text messages, letters, and things that were found by this lady
So-
eventually down the
Yes,
road.
sir. Based upon the
He
request
brings
that's
her
before
in.
me,
He
which is
promises
only
her that
to
he's
put in
going to
and read
buy her a
into evidence
ballerina
these
business
two
and get a ballet
sentences regarding one of the
troop together.
propositions that was considered
That
by
doesn't
DNA
happen.
labs and interpreting
falls
their
apart
test
financially. She gets
Certainly that
pregnant,
would be even more misleading because it doesn't
and then she
get into
discovers
the
that
other proposition
the issues
and
he
the other
had with his
testing that
previous
needs to be
wife.
done.
There's several
based upon that,
disturbing
do you wanna
incidents.
have
One
this
where he
marked
shoots
and
a gun
put
into the
into evidence?
ceiling,
Yes.
As a
turns the
profit.
gun on his own self, throws a gun at her, punches their
You wanna
dog
put a
so
number
hard
on-
that the dog
what's your
goes
next number?
unconscious.
29, but this is.
She eventually realizes she's made a big mistake and
Hold
she
on,
flees to
you're
Florida
handing
to
me
get
a
away
stack of
from
paper
him.
that's about, what, an inch and a half tall?
Yes.
And the only thing you said you were
And
gonna enter was this
he follows her.
5-page.
She gets an injunctive or an injunction against him to stop him from coming around. So for like a year, he doesn't even have access to her
So
or
it would be your
the
intention
child or anything like
to
that.
admit into
He moves
evidence
to Florida. He hires an attorney,
Defendant's Exhibit
Um,
29.
and eventually
What does this go into?
gets
No, that, I believe, is in there.
access to her because the court says that she's got to start giving visitation to their daughter, which she then says, okay, if he's going to get visitation, I'm going to go along. I don't want him alone with the daughter, knowing he's abused animals, knowing he's been abusive to his previous wife, the history of abuse, the things he's done. He even attempted to
I'll let
poison
you
her
put
by,
whatever you want up.
this was when he was still in South Carolina. He sent her a box that had some sort of poison in it, which she took to the police.
Yes,
He
absolutely.
attempted to get around the injunction
Beyond,
like,
I thought you already did.
by
This is
moving-
the profit.
trying to buy a house
I'd
that
like
was
to make verbal proffers
like
to
100 feet behind her
precisely why I
house
think
where she was living with her mother.
Yes, sir.
So,
They end up engaged in a big custody
unlike
fight,
the DNA
and
report that's
doctors get
in
involved,
court,
and
which
she keeps
requires
losing,
a chain
and
of
they keep
custody
awarding,
so that justice
continuing to keep him
is,
in the life of her daughter.
established.
Eventually, she decides, I want to get the hell out of Florida because Florida's not listening. I'm going to move to Maryland, where she was originally from, and see if when she gets up there, she can get away from him. And then he files paperwork
And we believe
to
it's
seek permission to move to Maryland and get the injunction thrown out so he can move with her to Maryland. And that's where they were at when the shooting happened. So she ultimately decides, well, you know what, I want to get out of the Florida system. When we get up to Maryland, I can try to get up here to Maryland and enter the Maryland court system and see if I can get relief up there.
Irrelevant. We are making no objections to chain of custody.
It's a day before they're about to, or a couple days before they're about to move.
That I
A
submitted
report's
to the
about to
court,
come out
shorter case.
that is going to show that she really doesn't want to be with him or reconcile with him like he's thinking that she's going to potentially do. And an altercation breaks out. He tells her that it's now time that she starts acting like a wife. They get into the argument that they get into. It gets physical. He punches her and chases her down in the house. She grabs the firearm that was packed, fires at him 3 times and kills him and runs to the neighbor's house. State comes in and says she didn't have enough physical damage.
Maybe I'm misunderstanding.
They went back and looked at the court record and said, well, there's been, all the courts were finding everything unfounded, and
touched Ashley Benefield's
eventually
hand.
they charge her.
That's what
And here we
I
are.
believe this says, and that's what I think
So,
we should be
it's a
entitled
very
to get to the jury.
disturbing case. He should not have, or she should not have
You
been
want that
prosecuted.
Right after the first page?
Definitely should not have been prosecuted. We got 162 likes, guys. Can we get to 200?
Okay. Yeah,
So I'm just
I
putting
got
it right behind it.
Sam Wright, I have no idea. That's why I want to bring attention to this case. Like, share,
As I said in my ruling,
subscribe. We need to bring
I
attention to
think
stuff
that
like
those
this.
questions
These prosecutors
and
need to be
what that
called out.
means and how it's interpreted and how the jury can use that to be relevant to its deliberations and its findings. I'm not saying it's not relevant. I'm saying the problem is 403, as the fourth DCA recognized, not having that analyst
No problem,
causes
Sam, right.
significant 403 problems.
Toto, you can
with
double click
confusion
the
and
screen,
misleading.
or you can hit the three
So
dots
that's
at
the
the
basis
top.
of my
If you
ruling.
double click the screen, it'll like it automatically.
That the actual DNA lab expert is available, but not until after 2 tomorrow.
Nothing out here. Why do you think she's definitely guilty?
There's
Yeah,
motion
double tap your screen and you can
3.1.
like this stream,
Florida Rule of Criminal
man. We get up to
Procedure
200 likes.
3.116
It helps
defines
promote this. It
how
helps
and
get
when
this
that
case
can
out. It helps get this in front of people. We've
So-
gotten over
I
109,000
just,
people
we
who've
need to
been
bring the jury
involved,
back in.
have come
I
in and
just
seen
need to
this
know
stream.
If your intention is to call more witnesses or. if
But it
you're-
happened in Florida, so it happened in a place that's very amenable to self-defense and self-defense theories such as these. So it's a good shot she'll be acquitted.
There's Florida Rule of Criminal Procedure 3.116.
Sharon, I don't know that he's
very
been
specific.
completely unfair to her. I think
It
that's just more posturing
came
by the
into
defense.
effect, it was just
But I think he's made some.
substantially,
I think he made a
I'll
mistake
say
with
substantially,
not allowing stand your ground to
amended
apply.
effective July 1st of this year.
This is the
regarding
Black Swan
use
case.
Of remote technology.
Yes, it is.
If you
Caitlin
want
Rayo,
some time to
Ashley
look at that,
Benefield.
I can certainly give you that.
I'm familiar with it.
Yep.
So are you?
Exactly right.
We'll rest.
Okay.
It's a
When you
bad
bring the jury
situation.
in, I will,
Anybody who abuses animals,
do
in my
that,
opinion,
then
I
I can
mean,
let them go for the evening. I'll tell them to be back tomorrow morning.
I'm not going to have a
8:45,
problem
just like
believing
we
that they
did
would be abusing a
the 9
woman or a
o'clock start.
child at that point. And if he's doing that to terrorize the woman and abusing her animal or her dog, that's, I mean, what else do you need?
Judge, just so you know also, we had submitted, the court may recall, requested copies of the proposed homicide charge.
I agree with you, Windy City Roses, and knock the dog out, knock the dog unconscious, and did it just to terrorize her because he was so mad. He punched the dog in the face. Absolutely
I will have
ridiculous.
to
I
look.
mean, sick. It's absolutely sick. And somehow,
Send
guys,
by
we
email?
went from an overwhelming amount of not guilty to 43% guilty. So if you have an opinion that she's not guilty, get your vote in. I can't believe that we have 43% of people that have voted. Only 117 have voted. We got 293 right now in chat. Let's see if we can. Let's get some not guilties in here.
Welcome back, everybody. Y'all can have a seat. All right, anybody?
Well, that's good, Tammy Mathias. He deserved more than a bloody nose.
Everybody says no. Mr. Taylor?
Self-defense, absolutely. Let's hit that not guilty button, guys. Not guilty or unsure, and unsure is almost as good as a not guilty.
Folks, at this point, it's 4:30.
Altera, you
Attorneys
changed
and I
it?
have some
I'm
work
sorry,
to
I
do
don't know that you
before
can
we
change it.
Get things going again in your realm of the case. So what I'm gonna do is let you go for the evening.
Well,
If you
and
could please be
not
back
nothing out
tomorrow
here,
morning
guys.
at
You know,
the jury
listen,
assembly room
self-defense,
around
the theory
8:45.
of
Just like today,
battered spouse
just, there shouldn't, there were probably
is
people
what
down
is
there
going to
today.
allow
I don't
this to
think-
be the self-defense.
Civil juries or do you know?
Because it allows other factors to
There
come
might be a
into the
small group
mindset,
tomorrow, there might be some
as
judges
opposed
and
to
civil
if this
court
would have been
picking some
between
juries.
two people and
So,
she shoots
find
him.
your area and kind of hang out.
Self-defense is going to be a tough
Deputies come down and get you
argument.
as soon
But
as we're ready.
in
and bring you up and
circumstances
get
that was
started.
present in this case,
remember the
because
rules
of
for
the
tonight?
abuse,
Don't talk amongst
self-defense is
yourselves,
still a
don't talk
viable
about the
defense.
case with anybody else, and don't
Guys,
research
20
out
away
legal
from
places
200
that
likes.
we
Let's
will
get it
talk.
going.
Thank you, have a good evening. Y'all can have a seat.
We got Wade Pad. Why do you think she's guilty, Wade Pad? Punching a woman that's not punching you does earn big boy prizes. Absolutely. PFC Town. Guilty. Why do you think that's guilty, PFC Town? Let's hear some facts.
All right, I'm gonna have to give you all, let me give you guys a 5-minute break. I'm gonna go upstairs and I don't have it in the pile I have with me, but I have a whole other pile. So let me run upstairs and see if I can find.
So right now, guys, what they're working on, just so you know, they're working on the most important part of the case, and this is important, and this
And
is
I
the
think
jury
you had also
instruction.
given me this case.
Shot him 3
Gonzalez
times,
v.
arm,
State.
leg, and chest. That's correct. Ran to the neighbor's house. 3, what time is it when she ran to the neighbor's? No, he was lunging at her during the shots. That's right.
It looks like the handwriting
but
that's been on a couple of your
this
other
is the most
documents.
important. This is what's going to define
And,
how this goes, what the jury instructions are.
So let me give it back to you. It might jog
they
your
give.
memory as to why you gave it to me.
This is where cases are won and lost. Okay. Give me one moment here.
Oh. We'll wait. I didn't look over. But
Yeah, so
wait.
actually, I remember, I think Gonzalez was our consideration and debate about whether or not we could get a charge of self-defense based exclusively on the 9/11 tape. We're a long way away from that.
All right. Do we just toss that? Or you keep it? Okay, sure.
I'm just trying to see if I have the right thing.
Sorry, Madam Clerk. I was trying to hold it back.
I just wanted to see if I had the right packet.
Well, let me show you, let me show you what I gave to the judge.
Right here.
Yeah.
I think it is,
I think it might be missing some of the highlights.
okay.
So it looks like you have the updated version.
All right, Ms. Benefield is back. So we're going to take a look at jury instructions now. So let me make sure that. All right, so defense, do you have a copy of the state's proposed jury instructions?
Yes, sir.
And state, do you have a copy of the defendant's proposed?
I believe we do.
And then I have mine that I did separately. if we could, I'd like to start with the state's version, and then when we get to an instruction defense that you have your own ideas or thoughts on, we'll see how we need to modify them or mesh them. So, Ms. Benefield, these jury instructions, as I've mentioned before, if I haven't, I will mention now, are very, very important. Too often, I think, people think of jury instructions kind of as an afterthought. But whenever we started this case, I had mentioned to the jury, and I say this several times, they listen to the testimony and receive evidence. They listen to the argument of counsel, and they listen to the instructions on the law by me. So this is 1/3 of what they are supposed to look at and consider. So the way that it works is, obviously, the defense has prepared some proposed jury instructions. I've got some that I've worked on, and the state has theirs. The reason I'm working from the states is that's just how we've always done it, at least in this circuit. It's generally the state prepares jury instructions. We kind of work off those. So as we go through, some of the things that I've mentioned in the past or have talked about or will talk about become much more clear when you really see the jury instructions and this is what the law is. So, Mr. Taylor, the way I do it is I'm going to, again, work from the state's version, which you have, and I'm going to call out the number. I won't read the whole thing, and just let me know in this first pass as we go through, do you have any objections, additions, corrections, or deletions to the standards? Then we can, after we go through that first pass, then we can get into some specifics.
Okay, and would that include omissions?
So,
Yes, absolutely.
sorry about that,
So,
guys.
for
I'm gonna
example,
step away
the
for a
first one
minute,
is
but
3.1
if you're wondering what's
introduction
going on
to
right now, the,
instructions. Any
the
objection to
defense
that?
rested earlier.
All right, so that's
Um,
good. Looks
so,
standard. 3.2,
Closing
statement of
arguments
the
will be happening
charge.
tomorrow.
Any objection, correction,
And what they're doing
additions,
is they're going
deletions to
through
that?
the jury instructions. This is where cases are lost and won. My dad
Right,
used to
looks
tell me
fine.
that this is the
Now,
meat and potatoes. It's
7.1,
the
introduction to
instructions they get here in a
homicide.
case like this that will
That
make
was
or
one of
break
the
this
ones that you
case.
provided to me.
And I think it's just the standard. Mr. Taylor, is it just the standard that you provided, or is there a difference?
No, I provided in my packet that I provided the court with, I provided the standard.
Okay. So there's no, I just wanted to see if there was a disagreement, because ours should be the standard as well.
Mhm.
So,
So if you look at the,
But mine was not edited.
understand, no, I see that. Yes, sir, you just gave me, yeah, the actual printout that I look at from the Florida Supreme Court website. But, so as you look at 7.1 as proposed by the state, do you have any objections to it?
Judge, the problem that I'm having with this is I haven't.
All right, guys, so I just checked.
Review this.
We need 12 more likes, guys, to get to 200 likes. So help me out. We're at 42% guilty, 25% not guilty, and 33% unsure. So I'm shocked at how the guilty
This
have
is why I
surged
call
here.
this my first pass. It's really a 30,000-foot
Okay.
overview. I mean, it's not uncommon, right at the end,
Well, Ruth Rodriguez, there
I
was
have this thing about
testimony this
Oxford
afternoon
commas.
from the defense expert.
And I think they need to be used.
He was moving towards
I don't
her. He was
understand
lunging.
not using them. But, so there's quite a few places where
Mr.
we're adding commas and so forth. Please don't worry about
I don't
those kind of
necessarily
details.
agree
I'm
with
just
that, not
talking
when
in
it comes to
general.
self-defense.
And this is one, quite frankly, we can skip if you prefer you want more time to take a look at it. That's absolutely fine.
No, with that explanation, then.
I don't necessarily agree with that, Mr. S.
Can I
Okay.
tell you, it's standard other than we added the charge and the name.
but if you see any typos or anything overnight, just let us know.
Yeah.
Person who is in a dwelling or residence in which the person has a right to be.
All right, the next one is 7.4, murder in the second
Has a right
degree.
to stand her ground and use threat
And the yellow ones, I didn't know if they were applicable, so especially we make sure that
reason that that distinction is made in these jury instructions is because it
I think as I look at this overall, it looks like you've got just the standard in there. It looks okay. The issue is going to be if you all.
Felicia
want that
Marie, yes, they
highlighted
did have,
portion,
they had a
if you want
child
the,
together. In fact, that
sudden
was one of the
provocation.
sticking points here. That was how he got
And,
back
and
in
I
her
don't need a
life.
final answer now.
Now, everybody
It's
needs to
highlighted,
understand,
so
she
you'll be
attempted
able to
to
let us
flee
know if you
him.
want that or don't want that.
She fled to Florida
It's in there for now.
to get away from him, and he used the fact that they had a
Possession of
child
firearm
together
and
to get access
discharge
back
causing
to her
death,
and
3.3D
continue terrorizing
should
her.
just be the
So
standard.
you need to understand that. For those of you who say, well,
1020
she could have
life
just left,
instruction.
she tried that. She tried to go the way of the court system, but it ended up coming down to where they had a confrontation.
All right, 3.3D looks right to me. And in fact, the one that I have from the defense, page 7 of 28,
Yep.
except for
All right,
typeface.
guys, we
it's
got 10
exactly
more
the
to go
same.
till we hit 200. Let's go.
3.4 lessers. So this is page 8 of 28 on the defense.
Well, Felicia Marie, that's the defense, is that she had battered woman syndrome. That is the exact defense. Nicole Dignam, she did this because of battered woman syndrome,
I believe that that's
which allows them to argue self-defense.
as to the
That's the whole
introduction
case
of
here,
lesser.
based
No,
on
I
what he
understand.
previously
If you
did
want
to
to, that's
her,
fine, but
played into
However, it's our
the
position there should not be any less.
events that led
right.
to him
So
taking his life.
are you,
Or her
are you
taking
prepared to
his
make
life.
that argument now, or do you want to wait? It's up to you.
I think I can probably
192
make it
likes,
now.
guys. Let's keep them coming.
Perhaps with the court giving me the consideration that if I think of something overnight, I might be able to supplement.
That's fine.
So we would cite the court to the Roberts decision, State of Florida versus Geraldo Roberts at 694 Southern 2nd 825, second DCA case. It was a charge of attempted second-degree murder, aggravated assault, discharge of
Well, Felicia,
firearm
I think
from
that we have to look at it from that
and
standpoint. She
carrying
doesn't look
concealed
remorseful
firearm.
because she was being abused. I mean, you're not. You have to look at it. She was
Reversed for the
in
trial court's
in a
failure
case
to
where there's
give an
abuse
instruction on
present.
attempted
It flips
manslaughter
everything
and on
around.
definitions
She's
of
the victim.
justifiable
He's
and
the
excusable
aggressor. He got
homicide.
killed in an aggressive act.
But
So therefore, you're not going to see.
there
You're going
is
to
a
see a
statement
different
made
type of remorse in a case like
as
that.
follows. The trial court must instruct
You know,
the
because
jury
she
completely
was,
on
he
all
was,
necessarily
you know,
included offenses,
in the moment that it
regardless
occurred
of
in,
the
she
facts
felt that she
of the case
did what
support
she
the
had to do to
instruction.
survive and walk away with her life.
In this case, the trial court was required to give an instruction on attempted manslaughter and on the definitions of justifiable, excusable homicide. Trial court's failure to give the instructions is fundamental error and can be considered on appeal even though defense counsel did not object. And then they cite Ronaldo.
And on top of that, I think it's also a
versus
mixture of
State,
exhaustion.
also a
I think you can
second
tell
DCA,
she's exhausted. She's stressed.
Decision 614,
You know, so I think you can't really judge what you're seeing there.
and parenthetical for what
I can't believe you
Ronaldo
haven't heard about
said
this, but I'm in North
conviction
Florida.
for
You're in.
second-degree murder
Okay,
reversed
Mayor O'Donnell,
because
welcome.
the
Thank you
trial
for coming in.
court's failure to include
No victim's going to sit still and take
definition
abuse.
of
I agree. I don't think she's
justifiable
guilty, but her lack of
homicide is part
emotions.
manslaughter
Yep.
instruction.
I agree with you 100%.
Even
Well, her
though
gun was ready in her
defendant
bedroom
failed
that
to
day.
object.
What a coincidence. Well, Ruth Rodriguez, it's not that it was ready in her
Say
bedroom.
this, then, at
She
that
was
point,
moving.
only
They were in the
exception
middle
to
of
this
moving, and
rule
it happened to be in a
is
place
if
that was
defense
available.
counsel
She also,
affirmatively
she carried a
agrees
weapon on her every
to
day in
the
her purse. She had a
omission or
license to carry.
alteration
So it was not like it was not like having a weapon around was some sort of indicator that she was planning to kill this guy.
Ashley Benefield, we request no lesser included offenses. We think this is an all or none plea. She either is guilty of second-degree murder or she's not guilty.
State, do you want to be heard?
Just that we disagree, it's a category one lesser and the state's asking to include it.
Okay. For right now, I'm going to tentatively say leave it in, but again, you want to look at some stuff? No, I'm familiar with the case though. Yes, sir, I'm very aware of those. You wanted some more time to look and see if you could find anything, so
if I
that's fine.
come up with anything else.
Leave it in for now, and as I look at manslaughter, it does look correct.
It appeared, the manslaughter instruction appears correct to me. However, I'm just not sure about the applicability of the various subsections.
Woven Creator, this is a case where this woman that you're looking at was being abused, and she took action, and she killed her husband. Right. Well, very similar. Yes, I could see that, Windy City Rosen. So when she carried her gun around, she took unsafe.
The next page is the
I think she just carried her gun around because it was her right to do so. She took the time to get a permit to carry, so she carried it.
Yeah, 3.38 looks like the standard.
But I think the people in Florida are going to be amenable to her arguments here.
Excuse the bolding, Judge, I just don't think we got that far without fixing it.
Elliott in Alaska says she'll violate within 3 to 4 years. Well, that's if she's found guilty.
3 different pages here.
Jordo OC, I think, hey, listen, I don't think you should judge it that way. You need to judge it based on the evidence. Right now, our poll, 44% guilty, 24% not guilty, and 32% unsure. Guys, we need 2 more likes to hit 200. Can we do that, guys? Come on. We've got 293 of you. Can I count on 2 of you to hit the like button? $204 likes. Thank you guys for rushing in, man. That's awesome. Thank you guys. Thank you very, very much. Hit that like button and hit that subscribe button as well, guys. Let's see each other again, hopefully, because we're going to be covering this. Tomorrow is closing arguments, as you're hearing. We're going to have the state's rebuttal case and closing arguments, and then this thing will be to the jury tomorrow night. Probably won't begin deliberating till Wednesday.
Ashley Benefield was justified in using deadly force if she reasonably believed that such force was necessary to prevent. Of course, we know there's 2. I'm sure you want A, imminent death or great bodily harm to herself.
Yeah.
Are you also asking for an instruction on the forcible felony?
Absolutely.
And I saw that towards the end of your paperwork. And it looks like you're asking for, you see that state towards the back of their packet? It looks like you're asking for burglary, felony bat, ag bat, ag assault, false imprisonment, that looks like all of them.
Burglary.
Yes.
Felicia, she did not move to Florida with him. He followed her to Florida.
Oh, okay.
Burglary, felony bat, ag assault, and false imprisonment.
She attempted to leave. She attempted to get away from him. She filed court. She tried to use the court system to do the right thing, and the court system failed her terribly. It's a very tragic case. She's not mentally deranged. She was abused by this man.
Well,
This
I think
man had
that's
a
your
history of
starting point.
abuse.
Yes.
All right, State, let's start off easy.
It's a very, very, very
Ask,
tragic
are
case,
there
guys.
any of those
Looks like we have
forcible
44% again.
felonies
The good
that
news
you
is
agree with the court
over
instructing the jury?
56% are either not guilty or unsure, which is solid because that means there's reasonable doubt in this case. So that's a good thing. So when the whole case has almost been presented, there's going to be the state's rebuttal. So to be at 56% either guilty, not guilty, or undecided is a good sign for her. I think it's going to be a not guilty verdict. I'm pretty confident on that.
312, but not relying on 7760131. So it seems like now you're supposed to pick, because it is repetitive. Because that same language is in each section.
And right now they're arguing
776.
and discussing
012.
the instructions, and this is a
It appears, I would say, that
very, very important
defense
part
is
of the
relying
case.
on
Extremely important part of the case.
776012, subsection 2. That's the self-defensive person.
It's the second part of that sentence. It says, but not relying on 7760313, and I believe they are relying on 776.013.
All right, that's protection in the home.
Denise Kelly, why do you think she's guilty? Why are you so sure of that? Jane Corrado, why do you feel that way? Why do you feel she is guilty all the way? Let us know, please. I'd like to hear your thoughts. The fluoride Kool-Aid. This isn't a death penalty case. So, but why are you so certain?
All right, do you see what the state's saying?
Terry
Yes,
Barr,
I do.
who is she? Her name is Ashley Benefield. She
Rather unique.
married a man after knowing him for 13 days. He turned out to be a terrible person, an abuser. And some of the things he did while they were together was punch their dog, fired
Let me just say that I,
threw a gun at her.
having served on many rules committees in the past, and currently
Unfortunately, she
serving on
made the
a rules
decision
committee,
to have
it is
him do
yeoman's
his
work,
vasectomy and got
what they do. And I can only imagine how many hours
she
went
found
into
previous text messages between
criminal
him
jury
and his
instruction
wife,
committee putting
where she laid out what an
3.6F
abusive
and
guy he was,
3.6G
and
together.
she fled the
And
he
I know sometimes we will
used
fuss,
the fact that
or I will
they tried
fuss
to
at the
access her and continued
complicated
to
nature
access her for
of
2
these jury
years.
instructions,
She
but
was attempting to
they
flee
really
Florida
are
to get to Maryland,
good, and I
get some help
appreciate
in
the work of
Maryland,
the committee.
and they ended up having a
So to put it
confrontation that
simply,
led to her shooting him, and now they're having a
on the
trial
standard
here.
jury
The state
instruction,
decided to charge her, even though there's overwhelming
from the
evidence
part
that he was
of
an abusive man.
give if defendant is relying on 776.012 sub 2 or 776.031 sub 2, but is not relying on 776.013.1.
Well, Ruth,
The 7760131,
the psychology of abuse.
as we know,
he bought her
gives even
as
greater
means to
protections
control her.
or establishes and explains
And
the
he
castle
starts to get
doctrine,
crazier and
from
crazier.
which
This is a guy
Stand Your
who
Ground expanded that castle
starting
doctrine
to shoot
out
people.
into
She
other
was on a
places.
cruise, and he overheard
But I think what
guys
the
in the background.
jury instructions are saying
her
in
talking to her.
interpreting the case law
He absolutely
is
came
that
up with some
if
wild,
the
crazy
defendant
stuff where
is
he said he was
relying
envisioning
in part
doing all sorts of sexual
on
things to her,
that
and said he
home
wanted to go
protection,
shoot them and kill them and do all this stuff. He was a nut
7760113
job.
subsection
He was-
1.
He
A
was
person who is in a
jealous,
dwelling
he
or
was abusive,
residence
he was crazy.
in which the person has a right to be, has no duty to retreat, and has the right to stand her ground and use or threaten to use, and then A, non-deadly, and B, deadly. And the reason that that distinction is made in these jury instructions is because if you're not, you automatically get those protections in the home, right? But 776012 is more of the general use or threatened use of force in defense of a person. And in that situation, the additional information that because it's not in the residence, the jury has to be instructed on the duty to retreat, or the non-duty to retreat, and a right to stand your ground if the person using or threatening to use deadly force is not engaged in criminal activity and is in a place where he or she has a right to be. Obviously, because 776013 is in the home, which Ms. Benefield was, would lend itself to the argument being made by the state that we would not have the first part of the standard, but we would skip down to give if defendant is relying on 776013 subsection 1, self-defense in the home, because it has all the same things, except now you're in your home, so the jury does not have to consider that you, whether or not you're engaged in criminal activity, or whether or not you're in a place where you have a right to be, because you are.
Judge, what is 0312?
0132?
No, 7760312. It says, give it
That's defensive property,
property.
yeah.
All right, guys. Just so hopefully you can hear me better now that I'm pausing I turned down the actual volume of the stream so I can explain this. There's some people asking what she did. She married a man after knowing him for 13 days. They had a child together. He was 30 years older than her. He baited her into the relationship by telling her that he was going to fund a ballet business for her. Unfortunately, he turned out to not quite be the man that she thought he was going to be. Unfortunately, she got pregnant first. After she got pregnant, he ended up really going absolutely insane. He punched their dog. He fired a gun into the ceiling in the middle of an argument. He threatened himself multiple times to shoot himself in the head. He threw a gun at her. He pushed her. He was physical with her. She found text messages that indicated that he was abusive to his first wife. She fled to Florida. After she flees to Florida, she has her baby. He, using the child, gains access by going, because she filed for basically a restraining order in South Carolina, which kept him away. He continued to violate the restraining order. He sent her a birthday package that had poisonous gases and materials in it. And did all of this while he's also at the same time trying to gain access to the child. They ended up in a hard-fought legal battle, which her his attorney came in and testified to, her attorney came in and testified to. He's able to, when the restraining order in South Carolina expires, he was able to fight a restraining order in Florida because he moved to Florida. Now, prior to moving to Florida, he put a tracking device on her car. He would show up at places where she was at. He was caught in her neighbor's yard spying on her. So once he was able to, through getting an attorney, he was able to gain access and get visitation with the child. She decided to placate him, which it was explained by experts in this case that women do this. They placate. They try to, when there's an abuser involved and a child, they want to try to keep the abuser at bay. And part of what how they do that is they will attempt to go along, get along. And the defense presented a large amount of evidence in the case about that phenomenon. As a result, they end up in a long, drawn-out legal battle. Eventually, frustrated that she continues to get turned down, she continues to get her restraining order request turned down. He absolutely was 30 years older than her, Miss K. You need to get your facts straight. That is absolutely a verified fact. Go back and look at the case, look it up. There was a 30-year age difference. He was 54, she was 24 when they met. Look it up. That is a verified fact. Okay? As a result, well, Terrence, go to my other stream. There's a link in there. You can go and listen to the case. This is an interactive stream. I have the case on a featured stream that you can watch it without me talking or any any interruptions. And that is attached to the that's pinned to the top here. We're at the end anyways. This is where they're working on judges' instructions. So, yeah. So go ahead and go over there, and you're not going to hear me. You see me talking, but you're not going to hear me. Anyways, so she ends up deciding that she's going to try to move to Maryland. She's sick and tired of all the BS that's going on in Florida. So as a result, she makes this decision to move up to Maryland, where she's hoping that she'll have better success in Maryland. A couple of days before they're set to move, they have his confrontation, and he pretty much is realizing at this point that he's losing control of her. And as a result, they get into this confrontation. He hits her and physically assaults her for the first time, where he hits her punches her. And he's kind of losing control of the situation. It's pretty much the way this is framed. And as a result, she shoots him in self-defense. Absolutely, Dawn Page. And Miss K, you can go over to the stream where there's quiet, and you can watch it over there. Enjoy your time out. You're not going to be commenting anymore. Well, she is not guilty, Evil Media. She is not guilty. She's not guilty. And what you have to understand is the defense has put on enough evidence. The judges found that's what's going on right now, where they're talking about jury instructions. But they have met the standard to where they're going to get the self-defense instruction. That's why they had to put the cases on and the experts on. So now, under the laws of our land, right, she's presumed innocent. So there was a burden to show by preponderance of evidence that self-defense was possible. So now the state has to disprove. That's why there's going to be a rebuttal case tomorrow. The state now has to prove beyond a reasonable doubt that self-defense didn't happen. And it's allowed, and the judge is giving an instruction, and when he instructs the jury, that if they find that domestic violence occurred and that there was a history of domestic violence, then they are allowed, if they conclude that that factored into her mindset at the time that the shooting occurred, that can be a basis for self-defense. Normally, it wouldn't be. Normally, self-defense is only the circumstances in front of you at that moment. But because the judge is going to allow domestic violence to be a factor in the history of domestic violence, that's the whole point of what the defense was putting on today, is it can date back to a year ago, 2 years ago. It's the whole course of behavior that comes into effect and comes into play at that moment when he's attacking her. He's terrorized her. He's hit her dog. He's fired weapons. He's come down. He's spent all this money. He's followed her down to Florida. He's tracked her. He's spied on her. All these things have happened. And now he's hitting her. Now he's letting her know you're done. Like, you're done. And he's coming at her. And he doesn't retreat. She pulls the gun out, says, get back. He doesn't retreat. He lunges at her. So she fires the weapon 3 times. Self-defense. And if the jury believes that there's even a remote possibility that that's what occurred, they must find her not guilty. Wendy, who's Wendy here? Let's see what's going on.
104, we've been referring to that as mugshot, and 105, we're now referring to as the boat picture. And the mugshot, my notes are 103 and 104 were not admitted.
Correct, and that was just an oversight. They were published.
All right, Terrence. Listen, pal, you've been in my lives before, but you're not going to sit here and say stuff like that. Here you go, buddy. Enjoy your 24. Enjoy your 24, my man. But Wendy is instructing you that there is a chat or a stream you can go to and watch in quiet. You're not going to have that garbage. That's one of the whole points there, Layla, is that she was targeted by him because of the age, and she was targeted for that purpose. Now I'm going to go ahead and turn the sound back on here. I wanted to go over that. You guys can listen to what's going on. Like I said, right now, testimony's over. This is more
State the next one
procedural
regarding
things.
aggressor and whenever the defendant, there's some evidence where the defendant was the main or initial aggressor, and then the force comes back when the defendant would be justified in using force when they were the aggressor.
I don't think there's any evidence.
I don't either.
I had already crossed it out, sorry.
Okay, is that all right? I don't recall any evidence that Ms. Benefield was the initial or main aggressor.
It's down at the bottom of the page, it says aggressor, and then it says Gibbs v. State right above it.
Yes, okay.
All right.
That's exactly
So
right,
that'll be
Dawn.
out.
And that's what I'm saying, and that's what they had testimony to is
The next part is
her
absolutely.
young.
Yes, I
'Cause
think
that's
the
the-
next 2 parts are.
Her
the
being
thrust of
young was a
defense.
big factor here. That's what a guy like him is looking for. That
So
age
prior
difference,
threats is in.
it allows him to be able to control her. It allows her. She's not making decisions from a huge
However, the
basis of
reputation,
life
I don't think
experience.
there was any testimony regarding reputation of the victim.
Agreed.
So the next 2 would come up.
Yeah.
And then the physical abilities.
So let's see where we're at, guys. We're at 42% guilty, 23% not guilty, 35% unsure, 228 likes. I appreciate it, guys.
Yeah, physical abilities
yes.
is in.
Absolutely.
Brooke Stevick, I'm sorry to hear about your experience, but what you're saying is absolutely very, very true.
If
It's
you
a very
would, that would be
difficult
great.
thing
I'd appreciate
to
that.
get away from because it.
All right, so see, this is why I
There
do
are
this
many
kind of
ways that
general
they can anchor
overview,
a
so
person
at least we can
down,
figure out where
and most of
the touch points
these
are for
individuals that
disagreement.
do that are.
All right, that's
skilled at
3.6F. We're not giving 3.6G, right?
Sorry.
Use of non-deadly force. Everybody agrees?
Yes, yes.
Okay.
Sorry, I got confused.
No, I just want to make sure because there's some cases out there that talk about both of them, you give one, you give the other.
I think it says now in the new standard, it said at the bottom, unless evidence establishes force or threat was deadly and non-deadly as a matter of law, and then it goes on and says the discharge of a firearm, whether accidental or not, has been deemed to be deadly force.
I'm still gonna belt and suspenders it and make sure everybody's
Absolutely.
agreeing, we're not giving 3.6G.
That's exactly right, Dawn Page. And that's
All
the
right, so
thing.
now,
When
these
somebody
should be
controls
pretty quick the
you
rest of the way. 3.7,
financially,
plead not
and
guilty,
from her
reasonable
perspective,
doubt.
it's like, you got to understand, she's trying to seek relief, and the police aren't believing her.
All right.
The prosecutors aren't believing her.
3.9,
He's got
weighing the
attorneys
evidence.
coming after her.
Now, on this one,
Imagine
Ms.
being in that
Benefield, of course,
place.
Mr.
It's a
Taylor's
terrible place to
has,
be
the
at.
copy right there.
And for her, and then he
The
he
10
elevates things. Remember, she
issues
knew
regarding
he
credibility
and
and
hit his
factors
previous
for the
wife,
jury to
that he
consider.
financially abused his
1
previous wife.
through
So here
5
it is.
are given
Goes from
in virtually every case I've ever been involved in. We do 1 through 5.
you know where
6 through
where
10,
he hadn't
however,
punched her
really
yet, to
depend
where now
on
he's
the
physically
facts of the
assaulting her.
case, and whether
And at
it's-
that point,
there's factual support.
she's
for
got a daughter.
forgiving
You know,
So
like I said,
6,
I think
any evidence of 6?
it's completely understandable
All right,
that in
6
that
is
moment
out.
she did what she had to do
7,
to get out
pressure or
alive.
threat. State
No, I don't think so, Judge. I think-
defense. Any argument you want to make about pressure or threat?
I don't believe so, Judge.
All right, 7 is out. 8, certainly 8 stays in because there's been some impeachment.
So we'll see what
8
happens here.
becomes
It'll be
6.
very interesting to see what happens.
9, I haven't heard, there's been no conviction,
Nine,
impeachment.
10,
All right, don't expect any of that. And 10, we don't expect any reputation for truthfulness or honesty? All right.
So,
So
you know,
looks
it's
like
just
8 becomes 6. and
something
one is
that,
good.
And then I just need to unhighlight.
you know, very few understand. It's easy
So,
for
yeah,
people to
page
look at
2
this
of that
situation and
is
say, I
gonna
would
be
have done this or would
unhighlighted,
have
but
done
needs
that.
to be
But
given. The defendant has become a
it's,
witness.
it's a very difficult
so- oh,
situation.
you already took out
And
3.9A?
like I said, in the totality of circumstances is what that
All right.
jury's gonna get to
Mr.
consider.
Taylor,
The
because this
judge
is our
is
first
allowing
trial
him to
together,
do that. So that's
at 3.9,
Absolutely
I stop.
great.
So for the initial instructions, I go all the way through 3.9, then I stop, and then I will explain the verdict form to the jury and go over it and explain how it works. That way you don't have to use your valuable closing time explaining how the jury verdict form works. You can just get right into it.
Okay.
When we come back, I'll touch on 3.10. And 20. All right, if that's everything we can handle tonight, you all are free to go, and we'll get started tomorrow morning.
All right, guys, so that is the end of court.
Yes, yeah, 8:45.
All right, guys, so there you see it. Court is over. So court is over, guys. You know that. Let's go in and I guess summarize this up. Take her straight to jail. It's like taking candy from a baby. Get him, Wendy. All right, so let's take a look here, guys. Let's see where we're at with the poll. So we're at 43% guilty, 23% not guilty, 34% unsure. So that's 57%. We're going to say are doubting this case. So that's after 557 votes. That's very good for the defense, because anytime you have a case like this where you've got less than 50% are sure about the case at hand, that's a great sign for the defense. Because I want you guys to remember this, and this is a final thought I'll leave you guys with, is the presumption of innocence lays with the defense. And that means that when she walked in that courtroom, if the jury had to render a verdict at that moment, a lot of people don't understand that. A lot of defense attorneys will ask that to prospective jurors. Do you know what your verdict should be right now? And I don't know. No, not guilty, because it's the presumption of innocence. So you're to presume the defendant not guilty. That is where it starts at. So the burden is on the prosecution to overcome that presumption of innocence. And if there's any reasonable doubt, if there's any doubt as to any explanation of innocence, you got to find them not guilty. And the way I like to lay that out is look, think of a line, like a number line, and you have 100 numbers. 100 is guilty. 99 is not guilty. If you fall anywhere along the 99 leading up to 100, it's a not guilty verdict. If there's even one reasonable doubt that she did this in self-defense, that she believed at that moment that a juror could say, I can't say for certain that she wasn't an abused person, or that there wasn't, or that she didn't perceive him as a threat, then you've got to find him or her not guilty. So that's where this jury's at. So that's why you see in Florida, a lot of juries are very prone to not guilty verdicts when it comes to self-defense. And I think that in this case, I think it's going to be a not guilty verdict. I think the defense did a heck of a job. She's got a very good defense attorney. They did a very good presentation. The state does have a rebuttal case to make tomorrow morning, so we will see that in the morning. And then we will see closing arguments. And I don't think we'll see a verdict tomorrow. I think a verdict will probably happen Wednesday, Thursday at the absolute latest. But this is going to be a not guilty verdict. Mark my words on this. I'm very, very confident of that. Because I think that they've made an outstanding case in this case that this guy was an abuser. This guy abused his previous wife. This guy abused her. And there's no way, in my opinion, that 12 jurors could sit in that box and say there isn't a possibility, that there isn't a doubt as to whether or not she shot him intentionally or not. I don't believe she shot him intentionally. And I just don't see how a jury could do that. So, that's where I think we stand. So, with that said, I think it's going to be interesting. It's going to be very, very interesting. It's going to be very, very interesting. If she's found guilty, she's looking at the rest of her life in prison, Layla. She's looking at the rest of her life in prison. Woven Creator, absolutely. Listen, I have a playlist with all 4 days of the trial. Go in there, run them at 2 times speed. I'm also going to be doing a day 1 through 4 where I've highlighted it up. I've worked on it. I worked on it all weekend, and I'm going to be putting it together. I'm going to be putting it out where we're going to be watching it. And it's probably about 2 hours long. It'll be at about two times speed. Yes, Woven Creator Life. Thank you. Yes. She's looking at life. Now, as you may have heard or not heard, they are giving a manslaughter instruction. So if there is a juror on there who says, I don't want her to walk out of this courtroom, give me one moment, guys. It's not my cat. It's my kid. Hold on one second. Anyways, I apologize, guys. So there's a possibility she walks out with manslaughter here. I don't think she gets found guilty of second degree. If she's found guilty of manslaughter, it's a victory, obviously, because she doesn't spend the rest of her life in prison. But she's still going to be facing, she's still going to be facing mandatory prison time because the firearm was used. That's the downside to it. And that's just how it goes, unfortunately, in the state of Florida. and I'm looking up the sentence here. I'm not exactly certain off the top of my head. Manslaughter, prison sentence. Let's see here. 15 years. So there's a mandatory minimum if convicted with a firearm of 9 years and 1/4 years. So she would do a minimum of 9 years if she's convicted. She has to do a minimum of 9 years. In other words, if you take manslaughter to trial and it gets convicted as a lesser offense, she's going away for at least 9 years. It's a victory, obviously, because she doesn't lose her entire life. But if she gets found guilty of second degree, she's going to be going away for potentially up to the rest of her life in prison. And I think this judge will do that. I don't think the judge is going to have any mercy because, again, he found against her standing her ground. He's not been in her side on any of the rulings in this case. So I think it's definitely a strong possibility that he goes and throws the book at her. Anyways, so with that said, guys, I'll be back tomorrow. We'll be watching as this case concludes. Share this stream. I appreciate the 232 likes. I appreciate everybody that came in. I appreciate everybody that joined. I appreciate the nearly 135,000 people that came in and viewed this and became aware of this case. So please come in and check out my featured stream if you want a more quiet approach where you can really digest the court case. Give me one moment. All right, guys, apologize there. I had to quiet down. My little one likes to try to be extra loud to get onto my streams when I'm streaming. He's all the way in the other room. Appreciate you, Windy City Rosen. You've been in there advocating for our side. Too Tall, thanks for informing everybody what's going on. There's been a lot of other people that have come in and interacted. I appreciate all of you. But share this stream, get the word out. At 7 o'clock in 45 minutes, we have a live premiere that you don't want to miss. It's going to be, it's about a case out of Wisconsin. It's a terrible case where a 27-year-old man is getting sentenced, and you're going to get background on the case and then sentencing and reaction to the sentencing. But it's a live premiere. Check it out. It's absolute evil example of the highest degree of evil in our society. You're going to see it in that case. Check it out. Coming up at 7 o'clock. I'll be in chat. Hopefully I'll see you in chat. Come on in, say hi, and check it out. And we'll go from there. So I appreciate everybody that participated today. Hopefully I'll see you guys tomorrow again. I may do a vertical live again. I may stick to my regular just featured live. It depends if I'm able to put up the vertical or not. But I've enjoyed the discussion today, guys, and be on the lookout. So with that, I'm going to end the poll, and we end the poll at 42%. Also check out the playlist to get caught up on this case. And with that said, guys, let justice prevail, and I'll talk to you soon.